and welcome Professor Venkatachala G. Hegde, sir. He is currently Professor of International Law and Chairperson at the Center for International Legal Studies, School of International Studies, Jawaharlal Nehru University, New Delhi. He also taught as Faculty of Legal Studies, South Asian University on deputation from JNU and had held the position of Associate Dean as well. Professor Hegde previously held senior positions at the Asian African Legal Consultative Committee, Legal and Treaties Division of the Ministry of External Affairs, Government of India. He was the member of several delegations to negotiate and implement treaties relating to international trade agreements and bilateral investment agreements. He represented India on the working groups of United Nations Commissions of International Trade Law, Vienna, Austria. He represented India on the working groups of United Nations Commissions on International Trade Law, Vienna, Austria. His main areas of work relate to international law, international settlement of disputes, intellectual property rights, international trade law, international law and domestic law interface, air and space law, and law of international watercourses. His work in the area of human rights as part of global collaborative project with 15 different leading universities under the aegis of European Union is well known. His work on the interstate water sharing in collaboration with South Asian legal scholars has now been published in a book named Springer. He was a member of the high-level task force on the development of Indian nuclear sector for the Institute of Defense Studies and Analysis, Ministry of Defense, Government of India. Professor Hegde has been a visiting faculty both within India and abroad to several academic institutions. He was Ministry of External Affairs, Indian Council of Cultural Relations, visiting professor at University of Leuven, Brussels. He is a member of editorial board of Indian Journal of International Law. Professor Hegde continues to be a part of various communities and assists of Indian government. He is an alumnus of postgraduate studies of law from University of Mysore and completed his LLM in international law from there. Later, he joined JNU to complete his doctoral studies. He continues to work and write in Kannada and has also edited a Kannada monthly Abhimata for Delhi Karnataka Sangh for more than a decade. He was president of Delhi Karnataka Sangh twice and was instrumental in initiating the development of its cultural complex and also in establishing a Kannada chair in JNU with assistance of Government of Karnataka. We are very humble and grateful to have you here, sir. Now I would request VG Hegde, sir, to deliver his lecture on evolution of international legal principles on sharing of international watercourses.
Thank you. Hope all of you can hear me. Yeah, you can hear me now?
Yes,
yes. Yeah, thank you, and wish to thank you for that long introduction. But first, let me begin. Can I start now? I think it's fine.
Yes, sir, please.
Yeah. So, good morning to all of you. And it's a great privilege and also pleasure to address the meeting on the topic today, evolution of international law principles, in relation to international watercourses. I first would like to thank and also my gratitude to Professor Ishwar Bhatt, who was my teacher during my LLM days. And also continuously, we have been in touch on various academic and other issues. I wish to thank him, and also let me also thank the KSLU colleagues, Professor Ratna Baramgaudar, Professor old friend C.S. Patil, Professor G.B. Patil, and also the registrar, Mr. Khan, and also other younger colleagues who are actually doing a wonderful work within the KSLA, which I am quite familiar with for various reasons. And I'm very happy to be part of this seminar on under the auspices of the Center for Water Resources Management. And it's very timely, and particularly with reference to Karnataka. I'm very keen to know, although I have been working on this aspect for last almost 2 decades, because because I was a desk officer in the Ministry of External Affairs in the Legal and Treaties Division when the UN Convention on the non-navigational use of water courses was adopted. So, and I was also on the working groups of Ministry of Water Resources as legal officer, young legal officer, and I had to attend and provide my assistance and legal advice to the government at that point of time in the formulation of the 1997 convention from the Indian point of view, and had an occasion to meet a number of very, very eminent engineers and legal scholars. And then from then onwards, I kept my interest in this area because it went up to Indus Water Treaty and many other international agreements which were concluded between India and other countries within South Asia as well. So I am very happy to speak on this aspect today, outlining what is the basic concepts which have evolved in the context of international water courses. But I will take it in a more broader sense. Because the international water courses, of course, is a very limited area. When we are talking about, as yesterday mentioned by Honorable Minister and also by the Judge, Mr. Manjunath, Honorable Justice Manjunath, it's a much wider concept actually. And with special reference to Karnataka is more interesting for the reason that even Karnataka has been facing a number of adjudications and cases and water distribution issues. Of course, Cauvery is quite well known. I'll come to that a little later. But so the basic principles relating to whether it is within India or within Karnataka or anywhere, the basic principles relating to water sharing, they have all come from international law. That's the first point actually I want to make. There was no sort of principle, I can say with an amount of certainty that existed within the domestic law. So if you look at the various aspects of the judgments or the arbitration awards of the tribunals within India, various tribunals, whether it is Cauvery, Krishna, Godavari, or any awards, if you look at it, it is actually, they all refer to the kind of international law principles, Helsinki principles, or UN convention, or some of the concepts which evolved there actually. So because inevitably that is how you look to arrive at a very, very important aspects of sharing the water without affecting the rights and obligations of the various parties to the adjudication or dispute. So with this particular background, let me begin my presentation. I have a PowerPoint. Please, can you show the PowerPoint, please?
Aditya, can you please begin the presentation, the PPT?
I have a very short presentation. It's not, it's about 8 or 9 slides. I thought it will be useful to have them because it will focus our discussion on the topics which I'm going to discuss in the next few minutes. So I begin the time he takes to do it. Let me explain that I begin my presentation with certain basic issues. It is very important to understand the limits or the the sort of outer limits of the legal principles which exist. What are the basic issues? Now, basic issues relate to, first is, as he is going to show the slides, first is, let's talk about freshwater resources. Globally, we know that freshwater resources constitute about 2% of the entire water resources. just 2%, 2 to 3% at the most. So it is not that, of course, we have a lot of water, like many people say, we are filled with water, but most of it is not usable. So, but 2% of the, or 2 to 2.5% actually, globally, we have freshwater resources. These freshwater resources are very, very limited in quantity. So over a period of time, when whether it is rivers, whether aquifers or lakes, you name them, around the globe. So all of them will have to be used in a very, very reasonable way, equitable way. Otherwise, what happens is this is going to become a problem in the long run. So first basic issue, we should understand that this resource, natural resource, water, fresh water, is a very limited very limited yeah, you can hear me? Yeah. So that's the first, the PowerPoint is being, now it has been loaded. Let me go to the first slide. Yeah, so I said limited globally to about just about 2%. I mean, it's not more than even 2%, 2.5%. So there is this is again, there is this problem between sea and land. Sea, you have a sea where, of course, you have a huge amount of water, but that, of course, depends on how you're going to use it. And even on land. So law of the sea and international maritime law regulate these both sea, particularly the sea related issues. But most of it is relating to non-navigational, navigational uses, plus, when it comes to maritime law, or it depends on the resources of the sea. I mean, they contain, as we all know, under the law of the sea, a huge amount of resources are available within the area of continental shelf or exclusive economic zone. The whole lot of, there is a whole legal framework which exists there. So we are not going to touch upon that kind of legal framework as of now. We are only looking at the freshwater resources which are available, which are equally important. Lakes, aquifers, groundwaters, and rivers. All these are extremely important for the life and quality of the people and then their existence. So, so this is a very, very important issue. And this is, I have mentioned earlier, it's a very limited resource. So obviously, any use of this resource over and above the existing availability is going to create a number of problems for the states, and of course interstate disputes, interstate problems. These are going to happen. So now the next point is territorial and international. So now this is not complicated. Any river or any lake or aquifer, whatever, which is within your territory, of course, you have the right to regulate it. You have the right to look at it the way you want to establish a policy, law, etc. That's what we do in India. But if it is a river which flows from one country to another or number of countries, then it becomes international. Then of course, water has to flow. Water has to flow from one place to another, and it has been flowing for ages, thousands of years, or maybe billions of years. Now that natural sort of flowing will have to be regulated. So obviously, and people have lived on this. And of course, the next one is navigational and non-navigational. There are the uses. I'm talking about uses of the, we need to know there are two kinds of uses. Now, later in the 90s, they, not even Helsinki principles spoke about it. They called it navigational use and non-navigational use. Even their legal regimes differ. In the navigational uses, of course, within your territory, or within your territorial boundaries, you actually regulate the navigational uses within your river, within your river streams. But once it is going to be non-navigational uses. What are non-navigational uses? I'm going to explain most of the international law regimes actually look at it. Non-navigational uses include, irrigation, drinking purposes, and then also generation of hydropower. There are a number of, it's increasing actually. Now, within non-navigational uses, there are two kinds of uses which are quite well established. One, where the water gets depleted, and in the second one, like hydropower, etc., water doesn't get depleted. This is very important actually in order to frame a legal framework actually. So when water gets depleted, then obviously you will have to have an agreement upon the based upon the lean season or flood season, depending upon the amount of water which actually comes into the river or to the lake or to the aquifers, or how to use groundwater. All this is very important. So navigational and non-navigational, I don't think there is going to be any major issues or problems. States actually regulate it, but there are, of course, different kinds of issues which actually arise. So coming to the point of evolution, see, role of rivers or lakes and aquifers quite well known over thousands or maybe more than that. Evolution of civilizations, evolution of human settlements, evolution of human thinking, all this happened on the rivers actually. I don't have to explain, this is quite well established. We know within our own country, most of the people established their lives because water is an important resource. So water is required. So we know that over a period of time, evolution of civilizations, the role of rivers, if you look at some of the texts which are available, including our Vedic texts, or even I think recently, if I can say in Kannada, ನಮ್ಮ ಹಿರಿಯ ಕವಿ ಎಚ್.ಎಸ್. ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಅವರ ಇತ್ತೀಚಿನ ಒಂದು ಪುಸ್ತಕ ಬಂದಿದೆ, ಅವರದ್ದು ಬುದ್ಧ ಚರಣ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಆ ಬುದ್ಧ ಚರಣದಲ್ಲಿ ಅವರು ಸಾಕಷ್ಟು ರಿಸರ್ಚ್ ಮಾಡಿ ಬರೆದಿರೋ ಪುಸ್ತಕ ಅದು. ಅದರಲ್ಲಿ ಅವರು ಒಂದು 4-5 ಪುಟ, ಅದು ಕಾವ್ಯದಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ ಅವರು. ಒಂದು ಆ ಬುದ್ಧನ ಕಾಲದಲ್ಲಿ ಒಂದು ನದಿಯ ಬಟವಡೆಯ ವಿಚಾರ ಬಂದು ಅದರ 2 ರಾಜ್ಯಗಳ ನಡುವೆ ಹೊಡೆದಾಟ ನಡೆಯುವುದನ್ನ ಅವರು ಬಹಳ ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ತಮ್ಮ ಕಾವ್ಯದಲ್ಲಿ, ಬುದ್ಧನ ಜೀವನದಲ್ಲಿ ಆದಂತ ಒಂದು ಘಟನೆ. ಆಮೇಲೆ ಬುದ್ಧ ಹೋಗಿ ಅದನ್ನ ರಿಸಾಲ್ವ್ ಮಾಡ್ತಾನೆ, ಆ ವಿಚಾರ ಹೇಗೆ 2 ದೇಶಗಳು ಆಗಿನ ಕಾಲದಲ್ಲಿ ಯುದ್ಧಕ್ಕೆ ಹೋದಾಗ ನೀರಿನ ಒಂದು ಬಟವಡೆಯ ವಿಚಾರದಲ್ಲಿ ಬುದ್ಧ ಅದನ್ನ ಹೇಗೆ ಅದಕ್ಕೊಂದು ಸೊಲ್ಯೂಷನ್ ಕಂಡುಹಿಡಿತಾನೆ ಅನ್ನೋದನ್ನ ಅವರು ಅದನ್ನ ಬಹಳ ಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ಅವರು ಬರ್ದಿದ್ದಾರೆ ಅಂತಲ್ಲ, ಬಟ್ ಆದ್ರೆ ಇತ್ತೀಚೆಗೆ ಅವರು ಬರೆದಂತ ಒಂದು ಇದರಲ್ಲಿ ನಾನು ಅವ್ರನ್ನ ಕೇಳಿದೆ, ಹೇಗೆ ಇದು ಬುದ್ಧನ ಒಂದು ಜೀವನದಲ್ಲಿ, ಅಂದ್ರೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಯಾಕೆ ಅಂತಂದ್ರೆ ಸಾಕಷ್ಟು ಹಿಂದೆ, ಅಂದ್ರೆ ಸಾವಿರಾರು ವರ್ಷಗಳ ಹಿಂದೆ, ಇವನ್ ಬುದ್ಧನ ಕಾಲದಲ್ಲಿ ನಮ್ಮ ನದಿಗಳ ಒಂದು ಈ ಯಾವ ರೀತಿಯಲ್ಲಿ ನದಿಗಳನ್ನು ಉಪಯೋಗಿಸ್ಕೋಬೇಕು, ಯಾವ ರೀತಿಯಲ್ಲಿ ಅದನ್ನು ಮಾಡ್ಕೋಬೇಕು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ವಿವರಗಳಿವೆ. ಅದು ನಮ್ಮ ಮಹಾಭಾರತವಿರ್ಬೋದು, ರಾಮಾಯಣ ಇರ್ಬೋದು, ಅಥವಾ ಹಲವಾರು ಈ ರೀತಿಯ ಟೆಕ್ಸ್ಟ್ಗಳಲ್ಲಿ ಇಂಡಿಯಾದಲ್ಲಿ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಈವನ್ ನೀವು ಮೆಸೊಪೊಟೋಮಿಯಾ ತಗೊಳ್ಳಿ, ಮಾಯನ್ ಸಿವಿಲೈಸೇಷನ್ ತಗೊಳ್ಳಿ, the world's all major civilizations evolved on the rivers. Why it's important? Because we are talking about historic rights, we are talking about traditional rights, we are talking about different kinds of uses of the river. Actually, the uses of the river are not something which happened only in the last 20, 30 or 40, 50, 60 years. This is happening for last thousands of years. So accordingly, when you develop principles, these principles will have to take into account the uses, the kind of dependence. Sometimes it's highly emotional. I mean, you can see this in our own context of Cauvery. People, Cauvery is not just a river. Cauvery is life. Cauvery is like is a living entity for both sides of the states. I'm not just saying that Karnataka or Kerala, Tamil, both all kinds. So rivers are, even Uttarakhand High Court has said this, and there are a number of very important decisions have come even from New Zealand, Australia, even United States, where they have given, even New Zealand, one of the decisions which has come recently has given a separate status, a living status, a separate living status to the river actually. And then accordingly, The river should be like a deity, where our Supreme Court talks about the deity who should be given a separate sort of an existence in order to devolve property, etc. Even the rivers are granted now around the world, not just in India. India, we have 2 decisions which have come. So the river, evolution of civilization, the role of river is very important. Then, of course, later emergence of nation states and boundaries have created a number of problems. We'll come to that later. Next slide, please. So these basic issues, we need to be very clear. And having looked at the basic issues, now let me look at the next slide, please. Can you move to the next slide? Yeah. So what are the contestations? Now the problems have come in relation to sharing. The first sharing, whether it is, not only rivers, lakes, all kinds of things, you need to really decide how to share, because the boundaries, for example, in South Asia, overnight with the partition, we created a number of problems relating to rivers. Overnight, when Bangladesh or when, came into existence, there are 56 rivers which crisscross between India and Bangladesh. And we have, with Pakistan, of course, we have Indus Water Treaty, but there are major river, Indus Treaty, Indus River, Sindhu Nadi, plus all the other 5 rivers, 6 rivers, which actually flow to the Indus, river. All of them became 2 separate entities. And then you have also irrigational facilities, the rivers flow, and then irrigation facilities had to be, taken into account. So sharing is a very, very important issue in this kind of things. Second contestation is about uses, actually. So I already mentioned about uses. Uses actually can become a problem because the kind of use you actually put a river into will decide the quantum of water, the quantum of its usage for the people. So that is the about diminishing of quantum of water. Actually, this was not a problem till a few decades, but it has become a problem in the last 100 years or so. Particularly in the United States, this jurisprudence relating to uses has actually evolved not only within the different states, but even United States Supreme Court dealt with many of these issues. Of course, navigational and non-navigational, I have already mentioned about it. Territorial and transboundary, of course, even that I have mentioned in my earlier presentation. So there is no inherent categorization of uses. All uses are very important. So now, taking into account these basic issues and contestations, I think international law essentially moved from informal to formal codification efforts. Now, let us look at how actually international law evolved over a period of time. Actually, it is international law which actually shaped the many of the basic legal principles which are being used today around the world, including within India, some of these, basic principles. So next slide, please. So the first effort to the next slide. Yeah. So can you go to the next slide? Yeah. Yeah. Okay. I think it is taking time. Let me explain. See, the first it is the first basic principles relating to the codification effort begins from the time when the almost 100 years, more than 100 years, 120 or 130 years. The first known case of the river water sharing problems arise within the United States. We talk about what is known as Harmon Doctrine. The Harmon Doctrine is, came into sort of prominence in 1895. The Harmon, Judicial Harmon was the Attorney General of the United States. He was the Attorney General of the United States, and he was asked for a legal opinion with regard to the sharing of Rio Grande River with Mexico. So Harmon, like a good lawyer, said that yes, the river, as and when it actually flows within my territory, I have absolute sovereignty. So this is known as Harmon Doctrine. So he said, he mentioned, this is a legal opinion he gave in 1895, But unfortunately, or fortunately, I must say more fortunately, the Americans actually discarded this Harmon doctrine immediately. Because the moment you say, absolute sovereignty over a river water resource which flows into your territory, then, of course, the other country which is above you, which is Canada, then he said sharing of Columbia River water in 1909, or even before that, when the negotiations are going on, they are quite happy about it. So there is this problem of upper riparian and lower riparian. So the moment upper riparian decides to exercise its absolute sovereignty, if you are upper riparian in some cases, you can be a lower riparian in some other cases. So then obviously the lower riparian, the upper riparian concept actually puts a particular state in a very big problem. So if you are upper riparian in some cases, and then you decide to exercise Harmon doctrine or absolute sovereignty doctrine, then you will be in the receiving end as a lower riparian. So obviously, in Indian case, if you check India, Ganges starts from Nepal, enters India, then goes up to Bangladesh and joins the Bay of Bengal. So, but here India is both the lower riparian and upper riparian. Bangladesh is a lower riparian. There is no choice. Nepal is upper riparian. Of course, Nepal is very unhappy with India on many issues of this kind. But one country which is actually dominant in this, and which is generally an upper riparian is China. And of course, Turkey. There are 2 or 3 countries which are essentially upper riparians, and actually they actually exhibit within their policy and legal framework this kind of an upper riparian approach to regulation of international law. So Harmon doctrine, of course, which we examine, but it doesn't exist anymore, actually. So no country actually follows absolute sovereignty doctrine. There are 4 different doctrines: absolute sovereignty, territorial sovereignty, select sovereignty, and then, flexibility that exists. So there are 3 or 4 doctrines which exist in relation to the sharing of international water courses. There is an excellent work, I'll come to it a little later, on these issues. So only way to resolve this issue is to United States, in the late 19th century and 20th century, understood that through a joint commission or mechanism to resolve these issues. These issues cannot be resolved just by taking a more sort of a formal legal approach, because the rivers are a very complex, rivers or even water sharing is a very complex sort of an issue, because it contains different, it actually, you have to look at different factors. These factors may not be amenable to a legal sort of a, solution. So the best way to resolve, which Americans and Canadians, and then this happened in that, period. So that's why they entered into sort of negotiations. They constituted joint commissions where you have engineers, you have lawyers, you have, different expertise available. Then you arrive at because you need to know quantum of water which actually flows in the river, how much is used, how much is required. Then you arrive at a particular sort of an agreement according to which it can be shared. And then there can be lean season and then flood season water flows. All those have to be taken into account, which are done actually. I'll come to that in greater detail later when I look at India. So that's how the first idea of joint commission mechanism to resolve these issues came up in the United States. Convention concerning equitable distribution of the waters of Rio Grande is in 1906, could be regarded as one of the best examples where they could do it through a joint commission. They did not take it to, more formal sort of a treaty negotiations, etc. After negotiating for many years, they arrived at this particular agreement, convention. So also for waters of Colorado and Yuan rivers in 1944. And of course, I can tell you Colorado is one of the most litigated US rivers actually. Colorado actually flows in California, Utah, Arizona, and then goes to at Yuma, enters Mexico. So I had an occasion to travel on Colorado from Los Angeles to up to Mexico. I went to Mexico also. This was some project, some visit. It was arranged for the study of the litigations which actually happened at that point of time. I had seen the Colorado River, including the Hoover Dam, which was built on the Colorado River in order to irrigate the huge the land areas in California and in Arizona, and then these are deserts. But now, because of the thanks to the river, and it was most litigated between 6 states around Colorado River, I'm sure there are more than 30 or 40 cases which went up to Supreme Court in order to arrive at a particular way of sharing this river. So in the United States, in the 18th and 19th, late 19th and early 20th century, these problems existed, and they arrived at, finally, I think they agreed that this cannot be resolved. I mean, even the US Supreme Court couldn't do it. So this decided that they will do it through a joint commission and mechanisms to resolve these issues. And they have done it quite well, actually. If you look at the 6 states around Arizona, Utah, California, and all these states there, they have actually arrived at, and then of course the water flows into Mexico, and there is a condition that Mexico should get the quality water. We are not talking about just the water, we are talking about the quality water. Actually, quality means that water should be usable. I mean, you can't deplete the quality of the water. You can't put chemicals or some other effluents into the river that will create problems to the downstream states. This is another obligation. So when it goes to Mexico at Yuma and then enters into Mexico, there when it goes to Mexico Bay and then reaches the Pacific Ocean, that is where exactly the water should be usable within the Mexican territory. That's what has happened actually. So it is the US jurisprudence, domestic jurisprudence, which has helped many of us, because now let me also tell you, next slide please. This was what happened in relation to even in our own context. So when you come to India, in India, Article 262 speaks about the, Article 262 speaks about the, two things. Please take the next slide. Article 262(1), it talks about a separate law should be passed by the Parliament in order to resolve the interstate disputes. Second, no court can intervene in these matters, including Supreme Court. Of course, on substantive matters, of course, of sharing, Supreme Court will not intervene. Of course, there are other areas where Supreme Court definitely can intervene. So Article 262 is a formulation which actually came up in the context of this kind of a joint mechanism, actually, negotiation. So when you have an arbitration tribunal, even if you look at the Water Dispute Act 1956, this is about use, distribution, or control of the waters or in any interstate river or river valley. No court intervention. So in other words, the idea is to actually for water sharing. So that hope all of you can hear me now.
Yes, sir. Yes, sir.
Yeah, yeah. So see, now the issue is about so Article 262 was constituted with a view to with a particular idea of to bring in the US experience. So now, if you look at Indus Water Treaty 1960 between India and Pakistan, it took nearly 10 years for both countries to negotiate this. It started there were, of course, I'm not going to get into the history of the Indus Water Treaty, but it took nearly a decade for India and Pakistan to negotiate this treaty, from 1950 to 1960. And both countries were not ready to sign this treaty, despite 10 years of negotiations. And both delegations, including Indian delegation, visited United States many a times in order to understand the way the US system worked actually. So now, of course, they came out with an extraordinary treaty, which actually perhaps one of the unique treaties, I'm sure, because where 5 rivers, Punjab rivers, were actually divided into, the waters of certain rivers, 2 rivers. It could be Satluj and, I'm not going to get into the 2 rivers, exclusive use of Pakistan, and 3 rivers, exclusive use of India. Exclusive use means that water should not be, the water which actually flows within these rivers can go into Indus exclusively without depleting any of the water. That will be Pakistan's share. So India can use the rest of the rivers for its own drinking purpose, can deplete the water, can use it for hydropower generation, etc., etc. So Indus Water Treaty setup actually is based on, after a long study of 10 years between India and Pakistan, examining the various US models. And you have, and of course, it's quite elaborate on dispute settlement mechanism, where now you have, Baglihar and then Kishan Ganga, and there are a number of arbitrations and then court of appeals have actually been concluded between both countries regarding the hydropower generation. So Indus Water Treaty is an example of a bilateral treaty which actually provided for a more joint mechanisms actually. So Indus Water Treaty dispute settlement mechanism, although is more binding, but what you have is Permanent Indus Commission. The Permanent Indus Commission is like under Article 8 actually provides for more flexibility. Both states can meet. Of course, there are a number of other problems, both political and other problems between both countries. So obviously, despite all that, in the last 70 years, the 60 years, this treaty is working fairly well between both countries. Both Indus commissioners, I was part of the delegation when the Indian Indus Commission, as part of the Indus Commission, Permanent Indus Commission, both India and Pakistan delegations meet either once in India or in Pakistan. And then, of course, the water resources secretaries meet and then they discuss. But sometimes when the relationships are not good, it's simply, the meeting gets over between 20 minutes. Both secretaries make a statement and the next, of course, they won't talk much. But the idea of a Permanent Indus Commission is to meet and agree to meet later point of time. So this is a very important issue because you may not agree, you may have a political problem, you may disagree, but at the same time, as I mentioned to you, the water is an issue which needs to be regulated because there are people from both sides have been using it for hundreds of thousands of years. So we need to take into account the requirements of this, people-centric problems which that exist. So obviously, the Indus Water Treaty takes into account all this, the issues, and it has been quite elaborately crafted. But although there were, rumblings at some point of time, that treaty, both sides, India, Pakistan, even within Pakistan, they are not very happy about it, and they wanted to go to International Court of Justice against this treaty because they feel that they didn't get the share of water they should get. And on the Indian side, of course, we have a different problems. So both sides have political problems in the way it operates, but it's still holding on. So Indus Water Treaty is holding on. And this is a 10 or 12 just articles this treaty has. has got about A to H, almost about 10, 15 annexes this treaty has, which actually talks in greater detail about the sharing. I mean, some of you should look at this treaty very carefully, although it has got a framework of 10 articles, but the annexes are quite elaborate, talk about the detail about how water should be shared, and what is a lean season flow, what is a flood season flow, and what do you mean by uses, what do you mean by exclusive use or non-consumptive use. All these were defined in the Indus Water Treaty in 1960. Why I'm saying this is at a time when international legal principles were not evolving actually. See, Helsinki principles came in 1966. International Law Commission started working on it around 1950s, and the convention came up in 1997. But it is India's contribution, India in the South Asian context. So Indus Water Treaty is a very important document, and it does not have a termination clause. The treaty does not have a termination clause. Like many treaties have a termination clause, this treaty doesn't contain, both countries either have to abrogate or renegotiate as per the Vienna Convention of Treaties, or it does not provide for a formal termination clause. So this treaty is a in perpetuity, unless states decide to do something about it. So it is one very good example within the South Asian context between two countries, which were one country at one point of time, and could able to arrive at a very, very, based on certain principles which they evolved, which actually through a negotiation joint mechanism. Then of course, you have within neighbors treaty on sharing of the Ganga or Ganges at Farakka 1996, which is again a lean season. Major treaty, Mahakali Treaty, all these treaty, both other treaties which with Bangladesh and with Nepal, Mahakali is with Nepal. So this treaty, both treaties talk about sharing of water resources in relation to lean season flow and flood season, flows. And this is important, particularly for Bangladesh, because these are, although perennial rivers, but sometimes in the summer months or winter months, it becomes difficult for the Bangladesh to get enough water for their irrigational purposes, traditional irrigational purposes. So, so these are, and of course, in '96, both treaties were signed, finalized after negotiations in 1996. Illೊಂದು ಏನು ಹೇಳಬೇಕು ಅಂದ್ರೆ, this is maybe a context. ಆಗ ಈ 96 ಅಲ್ಲಿ ನಾವು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದಾಗ ಇದರಲ್ಲಿ ನಮ್ಮ ಕರ್ನಾಟಕದ ದೇವೇಗೌಡ್ರೇ ಅದರ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಆಗಿತ್ತು. ಇನ್ನೊಂದು ಕಾಕತಾಳಿ ಅಂತ ಹೇಳ್ಬೋದು, ನೀರಿನ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ಆಸಕ್ತಿ ಇದ್ದಂತ ದೇವೇಗೌಡರು ನಮ್ಮ ಅವರು ಆಗ ಪ್ರೈಮ್ ಮಿನಿಸ್ಟರ್ ಆಗಿದ್ದಾಗ ಇವೆರಡು ಟ್ರೀಟಿಗಳನ್ನ ಸೈನ್ ಆಗಿರೋದನ್ನ ನಾವು ಗಮನಿಸಬೇಕು. ಅದು ಮುಖ್ಯವಾದ್ದು, ಕರ್ನಾಟಕದ ಒಂದು ಕೊಡುಗೆ ಅಂತ ನಾನು ಹೇಳ್ಬೋದು ಅಂತ ಕಾಣುತ್ತೆ ಇದರಲ್ಲಿ. ಸೊ ಬೋತ್ Ganges, there is a more sort of a permanent status has been given. Otherwise, of course, we have a lot of other treaties with both Bangladesh and Nepal on treaty areas. There are a number of different treaties as well. The construction of there are Kosi, there are a number of rivers on this belt. So on each one of them, India has been investing quite a lot of money. So this Indian approach is extremely important, that as a lower riparian, India is more accommodative to the interests of Nepal. So Article 262 I've already mentioned. Now let me go to the next slide. I have another 5-10 minutes. I must wrap up, I think. So now I think I'll come to more sort of a codification, how actually international was codified. The codification process, you can say, an institute there, Droit International. This is called Institute of International Law, very, very respected body. Established in 1873, this was Eurocentric, I can say, but their Madrid resolution on international regulations regarding the use of international water courses in 1911, followed by a Salzburg resolution on river basin concept, is the first sort of an idea about how you could look at water courses. The Institute de Droit International is a private body. Let me tell you this. This is very important to understand. The problem is, later as we move on from 1900s to 2000, there is always this problem between states and the private bodies actually arriving at certain kinds of creation of principles. So Institute de Droit International did, for the first time, and provided some of the basic concepts relating to the international regulations regarding the use of international watercourses. And then it was followed by what is very well known, popular, everybody knows about Helsinki principles on the uses of waters of international rivers, 1966, by International Law Association. Even International Law Association, you all know, is also a private body of very eminent lawyers. It is also a very old association. Even India has we have a branch in India as well. This works, thousands of lawyers meet, and there are several committees, but they came with, all of them codified. Helsinki principles were codified in a particular committee. It started sometime in the 1950s. Then by 1966, they came out with the idea of a basin concept. Now, you should take a basin of a particular river, a river which flows, like, for example, if Indus River is flowing from, say, it also has several tributaries joining the river, say from some river that comes from Afghanistan, joins the river, and then from India, 5 rivers are joining. So all this together, form what is called as a basin. So in order to share water, so Cauvery, we know the Cauvery water issues, we know about this basin concept. All these rivers, Kerala, of course, directly is not involved, but because there is a river which actually comes and joins Cauvery at some point, so Kerala is also party to the Cauvery dispute. So it is the basin concept which actually takes into account the Helsinki rules, which actually was framed by International Law Association, which is also a private body actually. See, these two are private bodies which actually codified in the initial stages some of the basic principles relating to international rivers. The first concept which actually should be taken into account is obligation not to cause transboundary harm. When a river is actually, if you're planning certain measures on your side of the river as upper riparian, then it should not cause harm to the lower riparian. So this again is from 2 cases. One is quite well known in international environmental trial smelter, the US-Canada 1939 case, and the Lake Lano arbitration of France and Spain 1957. Both spoke about the limits of transboundary harm actually. In one case, of course, it was trial smelter is nothing to do with water, but it was about fumes which were going from one side to the other. The other one is transboundary. Lake Lano is relating to water, where the water usage was an issue, both related to transboundary issues, where when a construction was taking place, you have an obligation to, next slide please. You have an obligation to inform or to provide information to the next lower riparian. You have an obligation to intimate or inform your planned measures to the lower riparian, notify the lower riparian. So these are the issues. And then coming to what happened was, within the United Nations, many countries were not happy with the Helsinki or even with the Institute de Droit International efforts to codify, because they felt that these are private bodies. These are not applicable to us, particularly Turkey, China, and these countries in the late 1960s objected to the codification done by these sort of country bodies. These are private bodies. So they said it should be formally done within the United Nations, taking into account the interests of the countries, states. So first time in the 1970, Turkey moved a resolution within the 6th committee, which is a legal committee of the United Nations, where it wanted International Law Commission, which is the formal body of the United Nations, where all states are represented or elected. India is a member of the International Law Commission for all these years, where the matter was taken up to study the issues relating to international water courses. So the convention on the non-navigational use of international water courses was finalized in 1997, which took nearly 25 years. The work started within the UN United Nations system in 1972, and then up to 1997, it's almost 25 years of the codification, and excellent work has been done by the International Commission. There are 5 rapporteurs who act, special rapporteurs who worked on this. Number of reports have been published, and states have given comments. And it defined the international water course in a very, very unique way. It called it a system of surface waters and groundwaters, constituting by virtue of the physical relationship a unitary whole and normally flowing into a common terminus. From the basin, we are getting into a more scientific, more user-friendly sort of definition relating to international water courses. Next slide, please. So UN Convention took, because states were parties to, this became state practice. So now the next slide. Yeah. So the UN Convention actually provided some of the basic legal principles, international legal principles. Let me quickly go through it and then finish. One is equitable and reasonable utilization and participation. Article 5 of to attain optimal and sustainable utilization. So that's a very, how to do it actually. So relevant factors, what are the factors should be taken into account is given in Article 6 of these are quite well articulated: geographic, hydrographic, hydrological, climatic, ecological, and other factors of natural character, social and economic needs, population dependent and its effect on other watercourse states, existing and potential uses. All these are mentioned in the UN Convention after a long debate between states. Of course, all states didn't agree to it, but still it is important to note this. Then conservation, what are the available alternatives, and obligation not to cause significant harm. This is a very important concept which actually was developed. Prior notification of planned measures. This, of course, India, China have a big problem because with in relation to Brahmaputra, because Brahmaputra on the Chinese side, they are constructing too many things, and which can create number of problems, flooding, etc. So we have an arrangement with China, which actually had to notify India in case if there is a planned measure or in case if there is a flooding, etc. So prior notification is an accepted norm as far as possible, and regular exchange of data and information. So I'm not sure all of this could be regarded as customary international law or accepted norms of international law. Very difficult to say, because as of now, states, different states, because this was voted, and out of 103 countries, 3 countries decided to oppose it, which included China, as usual, China, Turkey, and Rwanda, for various reasons. And rest of the countries, South Asian countries, including India, abstained. 27 countries abstained in 1997. And India had problems. Next slide, please. India had a number of problems with this convention. It actually abstained and made a statement. We prepared a statement. This statement talked about, the 97 convention allows the affected party on the other side of the border to come and take recourse to our judicial remedies. This was not acceptable to India. And India felt that this is not equally harmonizing the existing sort of arrangements. So there are a number of problems on this. India, we had a 1-page sort of an objections, and we made this statement and we abstained. And there are other countries which signed, but so far it has come into force. This agreement has come into force in 2014. 35 ratifications have been made. So, but still, I think to say that some of these are quite accepted norms, but not yet, I think they have attained the status of customary international law, which of course, obligation to not to cause significant harm, prior notification of planned measures, etc., could be regarded as almost touching that milestone of customary norms. The next slide, please. So I come to quickly, this, of course, International Court of Justice in 3 or 4 cases has spoken about it. Gapsikova-Nagimov's case in 1996, Hungary versus Czechoslovakia, is an important case which actually preceded just the the 97 convention, which referred to some of the basic principles, and then the 99 case, Kasikili, Sedudu Island, Botswana versus Namibia, then Costa Rica, Nicaragua. These cases I just mentioned for your information. These are three important cases wherein ICJ affirmed some of the basic principles. And the International Commission also has now come out with draft articles on transboundary aquifers in 2008, which is, of course, still in the process of making. Groundwater particularly is an important area on which codification process is going on. Yesterday, we heard about groundwater and then the problems relating to groundwater, which is now, of course, being codified. And I think with this, last slide, I think let me conclude by next slide. Yeah, I don't essentially Indian context. So in the Indian context, I'm sure my senior colleague, Mr. Mohan Kataki, is here. He's going to speak more about it. On the Indian context, adaptation of international legal principles in the Indian domestic context, I just mentioned them: concepts of cooperation and good faith, historical context of prescriptive rights, rule of priority of appropriation, rule of equitable apportionment, which of course is the international law 97 convention provides for it, and finally towards equitable and reasonable utilization and prior notification is an accepted normative concept in my view. And of course, things have moved now. You have sustainable development goals, and human rights to water is what is the key point which we are looking at. Dignity and quality of water is very important. So I think in the Indian context, we have almost 3 decades of jurisprudence. I'm sure Mr. Kataki will speak more about it, and I'm quite keen to listen to him as well on these issues. And there are 4 or 5 very important concepts. We have a jurisprudence of at least 7 or 8 different tribunals which are actually working and applying some of these basic principles, which actually come from international law or from the international legal principles. So with this, I complete my presentation. And I think it is the international law which has contributed, and countries have actually adopted many of these things. So thank you very much for listening to me with patiently, and then I'll be very happy to answer any questions if there are any. Thank you very much.
Thank you so much, sir, for sharing your precious words and ideas on evolution of international legal principles on sharing of international water courses towards codification, 1997 UN Convention and human rights to water. Thank you so much, sir. It was great having you here, sir. Now I would request Samir to take up and introduce our next resource person, Mr. Mohan Kataki, sir.
A very good morning to everyone present here. I, Samir Kagad, student of KSLE Law School, take this privilege to welcome Shri Mohan V. Kataki. Shri Mohan V. Kataki is a senior advocate in the Supreme Court of India. He has represented the states of Karnataka, Odisha, Punjab, Kerala, and NCT Delhi in several important transboundary water disputes before the Supreme Court of India and Interstate Water Disputes Tribunal. He is also honorary visiting professor, University Law College, Bangalore University. He has attended several international conferences, which include Biennial Conference of ILA at London in 2000, New Delhi in 2002, Toronto in 2006, Hague in 2010, Washington, D.C. in 2014, and Johannesburg in 2016. He is the Vice President of Bar Association of India, New Delhi, member of Editorial Advisory Boards of Students' Law Review, published by the Karnataka State Law University, and Bangalore University Law Journal, published by the Bangalore University. Also, member of Board of Management and Planning, Karnataka State Law University, Hubli. He was a member of Academic Council of National Law School of India University, Bangalore from 2005 to 2008. He has published a large number of articles, papers, blogs, and has delivered many lectures in international conferences and seminars. Key among them are Regional Conference on Water Resources at Teslik, Bonzia in June 2001 about equitable sharing of transboundary Krishna waters, Indian experience. Second, International Water Law Conference at Colorado Law School, Boulder, in USA, in June 2002 about equitable management and allocation of transboundary waters in India. Third, International Water Disputes Conference conducted by West Bengal National University of Juridical Sciences at Calcutta in February 2012 on the topic, if the climate change is a possibility, will there be reallocation of international waters? Fourth, 20th Law Asia Conference at Sydney in November 2015 about hydropower generation, transboundary environmental issues. Sir, it is a great honor and pleasure to have you with us. A warm welcome to you, sir. Now, I request Shri Mohan Kataki, sir, to enrich us with his thoughts on the topic, influence of international law on interstate water law in India. Please, sir.
Hello, am I audible?
Yes, sir.
Okay, thank you. Good morning to all. At the outset, may I thank my professor, Ishwar Bhatt, for inviting me to speak on this occasion. Before I spoke, Professor Hegde delivered a very learned speech. Previously, in Calcutta, we had been together, where again, Professor Ishwar Bhatt was instrumental in hosting one of the very popular interstate and international water law conference. I'm very happy that Professor Ishwar Bhatt has taken an initiative, and this is almost a second of such conference in India. The topic for today's discussion, which I chose a little last minute, was influence of international law on the interstate water law in India. The reason why I stayed clear myself from the problems of Karnataka or interstate water dispute is that since I have been representing Karnataka for the last 3 decades, such a long time, the time is for them to throw me out. And I have also been representing several states in the last 20 years. So it is a little problematic for me to speak about all these disputes because I have my own views on these things. So I usually speak whenever I'm requested to speak on the interstate water. I usually speak on the international water. Not that I'm a great fan of international law on the subject, but it so happens that the interstate water law and international water law have a meeting point and large points on where they agree together, and each have influenced the other. The international law has been influenced by the federal law because one of the sources of international law, as all of you know, in Article 38 of the ICJ, is general principles of the civilized nations. So, all applying this primary source of general principles of civilized nations, invariably the international court and the international arbitrations have referred to the federal law, federal experiences and practices or decisions of the court. That's how the international law has itself enriched with federal practices. On the other side, equally, the federal law has derived a lot from the international law in developing its principles. So, mutually, both have a law for each other, but both have certain areas of differences, as usual, because there are certain constraints in international law, there are certain constraints in interstate water law, which have to be separately addressed. One of the main constraints in international law is that there is no compulsory adjudication of the water disputes or compulsory adjudication of any disputes for that sake. You all know that the heart of international law is consent. So there cannot be a law without a consent. There is no international parliament to make a law. Everything has to develop out of a consent. Similarly, there is no international court of justice with a compulsory jurisdiction. What we have in international system of adjudication is that every dispute can go to the International Court of Justice or whatever the international forum only with the consent of the party, that if they agree to submit. The consent could be consent to submit directly, or consent could be a part of the previous treaty already, where it is stated that in case any dispute arises with regard to the implementation or interpretation of the treaty, the matter goes to the court, International Court of Justice, or to the arbitration, whatever they state. So adjudication in international law is not compulsory. It is something which is by consent. Therefore, many people say international law is still not has not met the test of rule of law, because there is no compulsory enforcement to the rights of the states if any state feels aggrieved by violation of international law by other state. So in this circumstance, international law has developed. Now coming to the interstate water law, as we all know, that one of the important feature of a federalism is there has to be an independent judiciary to adjudicate the disputes, whether it is a water dispute or a border dispute or any dispute, and render a decision which is binding on both the states which are party to the dispute. So the compulsory adjudication is a system which works in a federal system, and as a result, the development of law has taken more serious turn in the interstate or federal disputes or disputes within the federal system. So this is how the basic difference happens. So if you start with these things, we'll be able to find out to what extent international law has influenced the development of interstate water law, and that too in India. The transboundary water, to start with, is the water that flows from one political entity to another political entity, right? The river, which is like a corridor, a water course, we call it, gets water from the catchment, that is the area from where the water flows by a force of gravity, right? If you imagine the entire world is divided into one or other catchment or a drainage basin, the water that falls on the earth, it enters one or the other basin or catchment or drainage we call. So if you talk about the Krishna basin, which you can immediately relate, I'm just mentioning for the sake of understanding, it can, whatever water falls in the Krishna basin, that is the boundaries marked by a survey, they're natural boundaries, not a man-made. The water all flows first into the, for instance, the Dharwad, if you take, the water that falls in Dharwad goes into the Malaprabha River. Malaprabha River, it goes into the Krishna River. Now, if you go to the Karnataka University, that is the boundary line between the Krishna Basin and some west flowing river, Shamla River, the water that falls on the other side of the that Shalmala River goes into the other basin. So like that, the world is divided into the basin. And if you consider these basins as the natural boundaries, then the political entities have come into being in a different manner due to political circumstances. So there are two kinds of political boundaries. One is international boundaries, that is between the two independent and sovereign states, and the federal states, that is states within the federal system, like in India or United States of America or Australia. So this is how the two kind of systems have come in the transboundary water disputes. The transboundary water disputes have two different principles to emerge, but one common thing is that which runs common to both international order as well as the federal order, that is the states in both or the political entities in both have a duty to cooperate and share the water resources. Why duty to cooperate? Because cooperation is the most central point in promoting international peace as well as peace and cooperation within the federal system. So this international obligation to cooperate is common to both, that is to the federal states as well as to the international order. Secondly, the water is considered as res communis, that is, it is the heritage of the mankind. If that is the principle which is accepted around the world now, then it has to be shared. So both international law and interstate water law proceed on a same premise, that there is a duty to cooperate and there is a duty to share the water, because water, that is surface water, is the heritage of the mankind. Nobody has created the water. It is a gift of the nature. Nobody has an exclusive proprietary right. Therefore, it has to be shared. Now, what is the law for sharing of this interstate water or international water? Started begging the question in the 19th century. Why didn't come up before that is also the question many of you may ask me. The main reason why these interstate water disputes started emerging in the middle of the 19th century is due to the development of high dam technology. Till the high dam technology was not developed in the world by the engineers, there was no question of two states fighting over the same water, because water went down from the mountain to the downstream state by force of gravity, and there was no question of upper state holding the water by constructing any dam, except small barrages kind of things. So abundantly water was available in the downstream state, and as a result, a deltaic system developed naturally in the downstream state. Naturally, what we saw is emergence of civilization, culture in the downstream state, in the delta area, where the land is flat, where the sediments from the upstream state go and deposit. Therefore, if you study the history, I presume you have all been the student of history to a large extent. The civilization first developed in Nile Valley, that is Nile Delta, Brahmaputra and Ganges Delta, the common delta, Krishna Delta, Cauvery Delta, Tigris Delta. So all these major civilization in the world have developed in the downstream, that is in the deltaic portion. That happened because river used to flow down uninterrupted and to the benefit of downstream state, where they lived with the water. They developed mainly the rice as a crop to cultivate and earned, and around that culture developed. That's how the history of the world goes. But when the technology became available in the middle of the 19th century to construct high dams, the scenario changed. The upstream states, whether in the international order or in the federal states, started asserting their rights to construct the dam, hold the water, and transfer it to the dry areas to irrigate. Certainly, they have a right, because you cannot expect an upstream state to only to keep seeing the water flowing down to the downstream state. So they have the right to equally a right to utilize water. So in this context, in the middle of the 19th century, disputes emerged both at the international level and at the state level on the question of sharing of the water, because whenever the upstream state took up the dam, the downstream state would protest, claiming that it has affected our flow, which we have been historically using, which we have perfected by prior appropriation, which we have perfected by prescription. So various legal principles were invoked in order to protect their rights against the adventure of the upstream state. One of the first we come across is the Nile Delta, right? When the upstream state in the Nile started planning to construct dams to utilize, actually the people in the delta felt very threatened that what we have been historically using, the water, will all be diverted by the giant dam which the upstream states are going to build. That's how the dispute started. And same thing happened on the federal side. If you take, when Karnataka proposed, that is the old Mysore in those days, the construction of Krishnarajasagar, then it was called Kannambadi Dam at Mysore, the Madras people, that is representing the delta of Cauvery Delta in Tanjore district, protested, saying that this will affect our historical rights, this will affect our prescriptive rights, this will affect our prior appropriation right. So the protest led to the formation of an arbitration tribunal in 1911, headed by Justice Griffiths, and his award, and there later the matter went to the Secretary of State for India in London. So that all happened. So the point is, whenever the upstream state took up the construction of a dam by utilizing high dam technology that became available in the middle of the 19th century, the disputes arose. That's how the thinking on sharing of the water began. When the thinking about sharing of water began, the first question arose: how do we share the water? How do you resolve these disputes? How do you tell upper riparian state that you stop at X point? How do you tell lower riparian state that you can't expect more than this? So what is the principle? On what basis it should go on? Initially, the first thing, as Professor Hegde mentioned, was the Harmon Doctrine. That was the doctrine in international law evolved on the basis of the sovereignty theory, that each state is sovereign, it has no obligation towards any other state except cooperation. All that is required for any state is cooperate. Beyond that, there is nothing like sharing of water, nothing. Each state has a complete sovereign right to utilize the waters available within its territory. It has a sovereign right, it has a proprietary right. Therefore, regardless of what happens to the downstream state, whether it suffers or doesn't suffer, the upstream state can utilize the water available within its territory. This is the opinion of Harmon, who was the Attorney General of the United States of America, who propounded this theory based upon the doctrine of sovereignty, and it was accepted by American government. And they were successful in Rio Grande dispute in imposing this theory on Mexico. It worked very well. A small Mexico had no voice, so they listened to what Americans said, and that's how the Harmon Doctrine became popular. But this doctrine certainly went against America, as Professor Hegde mentioned, when the question arose with regard to the river between US and Canada, where Canada was the upstream state. So immediately America thought, United States of America or anywhere in the world, that this doctrine of complete absolute right to the upstream state is not going to work. It is going to create havoc in the international or even in the interstate field, because most of the water have already been, in any river you take, have been already utilized by the downstream state, because of the force of gravity, water has gone down, and in the delta region, where the land is flat, the water has already been utilized, committed, or exploited, harnessed, whatever you call it. So, as a response to this Harmon Doctrine, a new principle of law emerged, that is natural flow theory. This natural flow theory is just opposite of what Harmon talked. Natural flow theory said that the water must flow down to the downstream state in the state of nature. That means upstream state has no right to construct any dam, has no right to utilize water, except for a primary purposes like drinking water and some life-saving purposes. So beyond that, whatever he can utilize, that too by a surplus water, there is nothing like a right of an upper state. All water has to go down to the downstream state, and the downstream state may use it or may send it to sea. So this was the natural flow theory, which was based upon the private law theory of riparian private law theory, because in the English private law, if you read it, it is very clear that a downstream owner has a right to expect uninterrupted flow, and therefore the upstream owner cannot take it except for primary purposes like drinking. So this law was applied, that English common law, riparian law, to the international scenario or federal scenario, and it appeared immediately that it is protecting the most vocal countries, that is downstream states. That naturally worked for some extent. For instance, in Cauvery, all of you know that in 1892, the agreement was entered between the Mysore and Madras to protect the prescriptive rights of Madras. That was based upon mainly a natural flow theory, that water that has gone down to the Madras, it has a right, and which it has utilized, or the flow which it has perfected, it has a right. So in the agreement, finally, the crux of the agreement, what was it? The crux of the agreement in which was crystallized in 1924, first 1892 and 1924, is that Mysore, that is now Karnataka, cannot construct any dam or store water until the Madras gets particular quantity of water, that is called limit for the gauge readings at Upper Anicut, 6.5 feet. Only when the flow is above 6 or 6.5 feet in various months in a year, the Mysore gets a right to exploit the surplus water, not until then. That means a minimum flow of natural flow or minimum natural flow was assured to Madras, whether Madras needs it or not. That is how the law was understood, and that's how the agreement of 1892 and 1924 came under the regime of natural flow theory or riparian. So this is how the went on. Then the questions arose in the world, if we go by the Harmon, the downstream state suffers. If you go by the natural flow theory, upstream state suffers. So what to do? Justice Holmes very beautifully articulated in one of the case, New York versus New Jersey, that upper state has all the rights to cut off the water, and downstream state expects every water must come down to it in a state of nature. If these things applied, one will suffer. Therefore, the correct principle to be applied is both have equal rights, and the extent of their right depend upon equitable considerations. So that's how the principle of equitable apportionment arose in the international field as well as in the federal field. In India, the first time we had to think of equitable apportionment was in the Indus dispute. As I already said, Cauvery was the main dispute, which turned on prescriptive rights, which were based upon natural flow theory, because that was the law then applied. Cauvery in old days, that was before 1947, was between the two states, that is Mysore, which was the princely state, which was not a part of India strictly. The Madras was a part of the British India, that was separate. So the principle of this natural flow was applied, and that's how the dispute was solved in the name of prescriptive right. So in Indus, the dispute arose between the Sindh, one province of British India, and erstwhile Punjab, another province of British India. The dispute was referred to a commission headed by Justice Sir Benegal Rao, who is a well-known personality who was the advisor to the Constitutional Assembly of India. Sir Benegal Rao, in his beautiful report, I must say it's a classic actually, and it is one of the report which is referred everywhere outside India with great interest. In India also, of course, we do refer always. He extensively went into the status of the water, the rights of the states historically, and came to the final conclusion that no state has a right to cause injury to the other state. If injury is the basis, if no harm is the basis, then he said it can be solved only by applying the principle of equitable apportionment or equitable utilization. That's how first time the doctrine of equitable apportionment or equitable principle was laid down in India in 1942 by Indus Commission headed by Sir Benegal Rao. That the law stood. That's how the law in India applied. Now coming to the question, what extent the international law has influenced the Indian interstate water law system, what extent our water law has developed based upon the international law. Let us go to the basic principle again, that is the Interstate Water Law, the Interstate Water Disputes Act of 1956, Section 3 makes it clear that no state can cause prejudice to the other state. So if a prejudice is caused, a state has a right to lodge a complaint. So when the prejudice is the question, that implies that there is equality of right between the states. So the principle of equality of right, that equality of state, which is the principle of international law, developed from the Westphalia Treaty in the 16th century, was adopted in coining the interstate water law after independence in 1956. But the interstate water dispute did not spell out that they would they proposed to apply the interstate the equitable apportionment or the law of equitable utilization. But the tribunals subsequently, that is Narmada Tribunal, Krishna Tribunal, Cauvery Tribunal, and finally the Supreme Court in the Cauvery itself in 2018 has made it clear that the applicable law to adjudicate on the question of prejudice presented to the tribunal by a state under Section 3 is rules of equitable apportionment. So that's how the international law influenced the formulation of the Interstate Water Disputes Act of 1956 in India. This is the influence of the international law. Now let us consider how the judiciary has looked into the principles of international law in various specific situations while resolving the interstate water disputes. Way back in America, in the state of Kansas versus Colorado, the question arose, what is the law to be applied in resolving the interstate water disputes? The US Supreme Court put it very nicely. That is Kansas versus Colorado, 206 US 46 at 48. I quote, sitting as it were as an international as well as domestic tribunal, we apply federal law and international law as the exigencies of the particular case may demand. So as the exigencies of the particular case may demand, the courts have said we apply international law. It's not the court is enforcing international law. International law cannot be enforced. It can be enforced only if it becomes a part of a statute in India. That's a separate matter. But the courts use the international law by analogy, which is always available as a standard principle of law, to develop their own law, that is unwritten law by the judges. So that's how the principle of the international law started influencing the development of interstate water law or federal law, first in America, then in India. In between, in Germany also this question arose, and German Supreme Court said that where there is no German law, either in the constitution or the statute, we are free to apply the principles of international law because they are the standard principles universally acceptable, which can be a sure, perfect guide in resolving the disputes. So this is how the German Supreme Court and US Supreme Court thought of. Similarly, Indian courts also decided to apply the international law in 1969, from 1969 onwards. As I already said, although Sir Benegal has laid the foundation for equitable apportionment in his report in 1942, the tribunals, that is the first Krishna Tribunal, the another tribunal, went into the questions in detail again and came to the conclusion that the applicable law is equitable apportionment as developed in the United States of America and as developed in the international order, that is the law between the two states. So that's how the international law started casting its influence. The Krishna Tribunal in 1973 considered the matter, and after discussion, the report says it has certain reservation. Subject to these reservations, decisions of courts and tribunals and opinion of jurisdiction on international law may be consulted if they give sensible suggestion for resolving interstate water controversies. So it's not that we blindly apply the international law. The court cautioned, the tribunal cautioned that in a particular situation, if the international principle of law has some guidance, offers a value of guidance, then certainly the tribunal can adopt it. That's how the court in India looked. So if you consider all the three courts, that is United States of America in Kansas case, the Supreme Court of Germany, and the tribunals in India, they have applied the international law as an analogy, as the exigencies and the circumstances dictate in resolving the federal water disputes or interstate water disputes before them. Now let us consider what are these specific areas where the where the tribunals in India and later the Supreme Court had to apply the international law, how on the ground it was applied. First was, again, to go back, if I'm not boring you, that the basic principle of what is the law. As I already said, Harmon Doctrine spoke about the rights of the upper riparian. Natural flow theory favored the downstream state. Then the via media came, that is the equitable apportionment. So based upon the principle of equality of states, the tribunal adopted equitable apportionment as the law of interstate water law in India. Next question is, if there are agreements, what happens? The agreement is itself an equitable apportionment, is the principle in international law, which in India also is being accepted. The states have entered into an agreement, then the court need not go into a question of equitable apportionment and determine the rights of the states. It accepts agreement as a representation of equitable share of the states. If the states are agreed in the past, they are bound by it. Therefore, agreement becomes a law itself as an equitable apportionment. This is the principle of international law which the courts in India adopted. The question came in Cauvery whether the agreement which was entered by the princely state of Mysore, which was an independent state, which was a semi-sovereign state, with the British India, that is Madras Presidency, can be enforced today in a domestic tribunal, that is the Cauvery Water Disputes Tribunal, which is a tribunal constituted under Article 262 read with Interstate Water Disputes Act. Karnataka argued very strongly that, look here, this agreement was entered in 1924, before that in 1892, first agreement, under the system where the Maharaja of Mysore didn't have freedom to negotiate. He was not on an equal footing to negotiate with Madras because Madras was directly ruled by the British, which had a responsibility towards Madras to protect its interest. Naturally, they treated Madras on a favored footing than the Mysore. Therefore, the Mysore had to suffer. This was an agreement entered under the pressure. This was an agreement entered under the duress condition. Therefore, it's not enforceable. This is the argument which the state of Karnataka advanced before the Cauvery Tribunal. But the tribunal, applying the principle of international law, drawing an analogy from the principle of international law, said, look here, in international law, nobody can complain duress as a ground for invalidating agreement. Because most of the agreements in international law are entered after the war. The victorious power always imposes an agreement on the defeated power. For that reason, you can't throw out the agreement. Therefore, it adopted the principle of international law that the duress is not a ground for invalidating the international treaties. If I read the provision, observation of the Cauvery Tribunal for a quick benefit, it says, quote, but it is well known that international agreements as well as interstate agreements cannot be examined at a later stage on the touchstone of as to whether the terms were just and proper, keeping the interest of both the nations and the states at the time of execution of those agreements. Sometimes, compulsions existing at the time of execution of the agreement may be a factor for adopting the spirit of give and take on the part of one nation or the state. In any case, those agreements cannot be challenged now on behalf of the state of Karnataka. So the principle of international law that the agreement cannot be challenged on the ground of duress was endorsed by Cauvery Tribunal in its report in 2007. However, later Supreme Court in 2018, while agreeing with the Cauvery Tribunal on the ground that the agreement cannot be challenged, that the Karnataka the agreement is not invalid, but it took slightly a different line. It did fully endorse the international law as the tribunal adopted, but still the Supreme Court of India said, since the agreement lapsed in 1947, the Mysore had an opportunity to denounce the agreement. It didn't denounce, and later it was continued in 1956. Therefore, the present Karnataka is a successor to the old agreement entered by Maharaja of Mysore, though at that time it may have been entered under circumstances as it claims under duress or pressure. So that's how the different line was taken, but still the point went against Karnataka on this. So this is how the international law was sought to be applied in the interstate dispute. The second instance. The third is revision of the treaties or revision of the decisions. As you know that the water disputes, what we see, or the allocation of water or distribution of water is not a permanent affair. It keeps changing. If we determine today by a treaty that X is the equitable share of Y state, some state, And why is the equitable apportionment another state? That may not hold good after a period of 30, 40 years if the conditions change. Because the water availability changes, the climate changes, requirement changes, so many things changes. Therefore, question arose whether the international law principle of reversing standibus, that invalidating the treaty, that which gives a right to a state to invalidate a treaty, terminate a treaty on the ground of changed circumstances, can be applied in India by a state against the agreements which it had entered. The Narmada Tribunal had an occasion to consider this and came to the conclusion that it does apply. No agreement entered by a state, though there is no provision for termination, can be construed as a permanent agreement, because by very nature, the circumstances keep changing in the distribution of the water. There are various new technologies come, the quantity of water changes. Therefore, the treaty can be, or an agreement can be revised. So principle of international of reversing standibus is applied with regard to the revision of treaty, or sorry, with regard to the revision of interstate agreement, though there is no such clause in the agreement, if there is no such clause. Fortunately, in Cauvery, there was a clause that 1924 agreement will expire in 1974. So there was no difficulty. But the principle was upheld by the Narmada Tribunal in 1976. That is, the treaty is liable to be revised, that is, agreement is liable to be revised if the circumstances change. That's how the principle of international law was borrowed in respect of revision of interstate agreements in India. Then the third area where the international law influenced is the concept of basin. As Professor Hegde mentioned, it's not that we divide the waters of river in the sense that when you talk about Krishna dispute or talk about Mahadai dispute, it's not that the water that enters finally the stream is divided. Of course, that is the point of division, but the entire basin, that where the water generates, is considered. There are tributaries. Sometimes it happens that between the two states, the contact point is not only the main river, but also the tributaries or just a catchment. So in these circumstances, the disputes has to be resolved by considering the entire basin as one unit. This was the principle developed by the international law to better resolve in a more sensible manner the international disputes. The principle was adopted by the Narmada Tribunal in the Narmada water disputes, but with the reservation that utilization need not be confined to the basin because there could be an opportunity for the state. The state may have a right to transfer its share of water outside the basin for utilization. For instance, in Mahadai, one of the point of Karnataka was that we need Mahadai water, not for utilization in Mahadai basin. It is for utilization in Krishna basin, that is Malaprabha part of Krishna basin. And the trans-basin diversion we justified on the ground that there is a shortage of water in Krishna basin, that is at Malaprabha dam. And to meet that shortage, we need water. So basin concept has been accepted by the Indian tribunals, but with the reservation that each state has the right to transfer water outside the basin for life-saving purposes, for important purposes, provided there is surplus water, provided there is a shortage in the other basin or a recipient basin or a donor basin. That's how the principle of international law influenced, and we adopted it with certain modifications. Then comes the protection of existing uses or no harm principle, which is the most complicated principle in international law and the most controversial in the interstate water disputes also. Why it so is, as I already said, there is a certain pattern in the interstate water disputes or international water disputes. Historically, the water had been going by force of gravity and the downstream state where the delta exists, where the land is flat, the land is fertile, use the water to cultivate crops. And that's how the civilization grew up in Nile. You take in Mississippi, Tigris, or Indus, Brahmaputra and Ganges, or Mekong Basin, for instance. So all these basins, the deltas are important because historically water came down to them and they utilized it, right? So in these circumstances, the question arose, if you now decide to distribute the water on equitable apportionment, what happens to the state which has already used water much beyond its equitable share historically? Can you undo the history? Can you destroy the existing economy? So this is a very serious question because if the economy has developed, if the population has settled based upon the utilization of water, can it be destroyed in the name of equitable apportion? So the most important challenge to the equitable apportionment, which is being now posed in every dispute, is to what extent the no harm principle, or we call it a protection of existing uses, to be accommodated in demarcating the equitable shares of the states. One of the principles which the Helsinki very beautifully did was that in the equitable apportionment, one of the factor is existing use or the past utilizations. So if that is the factor, and the courts said in India, adopting the Helsinki principles as a guideline, that yes, if existing utilization is a factor, it is not only a factor, it's a dominant factor in particular cases where already water has been utilized. So therefore, first time in Krishna water disputes in 1973 report, the court said that, the tribunal, that existing utilizations of Andhra Pradesh, that is almost 749 TMC of water, is to be first preserved before we allocate water to others. But in the allocation of surplus water, the tribunal took care to remedy the mischief, took care to protect the interest of Karnataka and Maharashtra. In the remaining water, only 51 TMC was given to Andhra Pradesh to make it 800 TMC. So to that extent, we stood protected. But even then, Andhra Pradesh got 800 TMC over riparian. Upstream state got only 734 TMC. Maharashtra got 585. Why? It is because of importance given to the existing utilizations, historic utilizations, the need for protection of the existing economy. This has happened in Nile also. This has happened in any other basin, including the Indus basin, which Professor mentioned. India had to end up in giving 129 MAF of water to Pakistan, whereas it got only 33 MAF in the three eastern rivers which are at its command, that is Satluj, Ravi, and Bass. India has only 33 MAF of water, whereas the Pakistan, which is given unrestricted right to receive water and use it, gets almost 129 MAF of water. And even now, Pakistan has no plans to utilize more than 110 MAF of water. So, but 20 to 25 MAF of water goes to sea in Pakistan. India, I have written an article also. Why can't India negotiate with Pakistan to save this water which goes to sea? Because one of the important principles of law in water is that no state has a right which it does not use. The right depends upon the need. If you are not using it, you can't say that it is your right. The right to wastage is not a right of anyone. So India and Pakistan may have to negotiate and try to salvage this water which goes to sea. But it's a political questions, and I don't know how to go about it. There are various things, ways to go about it. That is to be left to the government at the political level. So this is one of the principles which influenced the law in India, that is protection of existing use or obligation not to cause harm or injury to the existing utilization. Then the next principle is guidelines for equitable apportionment. It's all fine to say that each state has an equitable share, but what is equitable share? So that's a very difficult question it became. So in the question of what are the guidelines, what are the factors to be considered, and what weightage to be given to which factor, in this regard, the Supreme Court of India in 2018, if you look into the Cauvery judgment, that is 2018 judgment, it is very clear that Justice Deepak Mishra was influenced by the principles of Helsinki and Berlin Rules of 2006, which is an improvement over Helsinki, in considering what are the guidelines, what are the factors which constitute the share of a state. The most important factor which constitutes the share of a state is a need. But everyone has a need. Every state has a need. Then how do you go about? Then there's a comparative need. Then the comparative assessment of the harm it might cause to the states. So all these things are considered in arriving at an equitable share. But again, most important is usually the existing utilization, which has to be properly dealt with by applying the modern principle. Because existing utilization does not mean utilization of water as per the old standards. It has to be as per the present standards. So here the question comes, what are the actual requirement of water for the existing user? Is it same as it was, or has it come down in view of the change of technology? If it has come down, then his share has comes down, because that saved water, the upstream state gets it, provided it is within its equitable share. So these are the difficult questions. Sometimes they say that like whether the egg came first or chicken came first. So this argument goes on. That's why the interstate water disputes are quite complicated, quite difficult, because of the not only the vagueness of law, but also because of the technical issues involved. The technology changes, the factors change. So the techno-legal issues which emerge in interstate water disputes are the most challenging disputes for any adjudicator system, whether it is Supreme Court in India or Supreme Court of the United States of America, which has handled so far US about 150 cases. And one of the famous cases is Kansas versus Colorado, which has been going on from 1902 and still going on. It comes back. So that goes on because things change, some new issue arises, then naturally the court takes it back. So this is how the principle of international law have influenced the interstate law in India. Interstate law owes largely to the international law. Both the Parliament, when it enacted the Interstate Water Disputes Act in 1956, it did consider the principle of no prejudice, no harm as the basis. Then the courts developed the principle of equitable apportionment, again based upon the international law. Then on the various contingencies which the court faced from the change circumstances, rebus standibus, or the protection of existing utilizations or no harm principle, or the guidelines, it has relied upon the international law. One more principle which should the court consider is the autonomous management of the water resources by the states. Once the shares are allocated, there must be an autonomous body to manage. Even that principle has been adopted by the Parliament in 1980 when they amended the Interstate Water Disputes Act and created a mechanism for this autonomous management of the water under Section 6A that reflects the principle of international law, that there has to be an autonomous management of the waters by the basin states. In fact, you must have come across the famous Mekong Commission, which all the riparian states to the river Mekong, except China, have entered a treaty to establish the commission, which will look after the interest of all the states. Of course, the absence of China has created a problem, the upstream state. That's a different matter, political issue. But an autonomous body is necessary. And in fact, in Krishna, the tribunal has recommended for the autonomous body. In Cauvery, it has already been established under Section 6A, that is Cauvery Water Management Authority. So this autonomous management of the water resources after the shares are demarcated is again a principle of international law, which influenced the Parliament in India to enact Section 6A and also influenced the courts in creating that. Because before the Parliament did it in 1980, the suggestion came from the Narmada Water Disputes Tribunal after extensive review and research that there is a need for post-adjudication an autonomous body to manage the shares of the states, to implement the order, That's how the suggestion came, and the Parliament amended the law in 1980. That's how the influence of international law pervades through the interstate water law in India. So, with these things, I would like to wind up. And well, whatever I had talked, I'll reduce it into a paper for the benefit of the students and everyone. If the KSLU publishes the book, I hope it will publish. Certainly, you will see all this with the proper citations. Thank you very much.
Yes, sir. Thank you, sir. Indeed, it was a pleasure listening to your enlightening scholarly words that made us aware about various concepts about international and interstate waters law and its disputes. Once again, thank you very much, sir. Now I request Shirshi, student of KSLU Law School, to welcome the next resource person.
Siri, let's just wait for Professor Tony George to join. Just give us a moment.
Yes, ma'am. Sure, ma'am. Thank you.
Yes, Akila, actually I'm online. Yeah. Okay. You should be seeing me now. Hello?
Yes.
Yeah. Okay, great. You're able to see me?
Yeah.
Yeah, perfect. Because I
Audible.
okay.
Yeah.
I'm audible now.
Yeah.
Yeah.
Sure.
Perfect. Yeah.
A warm afternoon to one and all present here. This is Sirishri, and this task of introducing our speaker, Professor Dr. Tony George. Professor Dr. Tony George Puducheril is a professor at the Jindal Global Law School. He is also a research associate at the Marine and Environmental Law Institute at the Sujit School of Law, Dalhousie University, where he has taught courses on Canadian property law, law of the sea, and Arctic Ocean law and policy. He is a senior research fellow with an International Ocean Institute, Canada. He is also a member of the World Commission on Environment and Development of the International Union for Conservation of Nature, Canada. He is a former assistant professor at the National Judicial Academy, India. A Canada graduate scholar, he holds a PhD in sea level rise, integrated coastal zone management and coastal law, and an LLM in maritime law from the Dalhousie University. He also holds a research-based MPhil degree in water law from the National University of Judicial Sciences, India. He has qualified the National Committee on Accreditation Exams for International Lawyers administered by the Federation of Law Societies of Canada. He is an internationally acknowledged expert in sustainable development law, and his research interests include the interface between law and sustainable development, law and governance in South Asia, ocean and coastal zone management law, climate change law, international environmental law, maritime law, and water law. He has been invited to present his works, among others, at the International Bar Association, the Commonwealth Judicial Examination Institute, Windsor Law School, and the Oslo KJ Jebsen Center for the Law of the Sea. He has more than 36 publications to his credit, and among his publications, the two major ones are the books From Shipbreaking to Sustainable Ship Recycling, Evolution of a Legal Regime, which has been acclaimed as the work on the subject, and Towards Sustainable Coastal Development, Institutionalizing Integrated Coastal Zone Management and Coastal Climate Change Adaptation in South Asia, book that should be read by coastal policymakers and decision makers from all countries. I would now request Dr. Puducheril to share his esteemed adjudication of the topic Cauvery water disputes and international water law principles. Over to you, sir.
Can you hear me?
Yes, you can.
Yes.
Yeah. Okay. Thank you, Meghna, for those kind words of introduction. So, So
Good afternoon, everybody. So my topic, as you know, is the Cauvery water dispute and international water law. So essentially what I seek to do in the next half an hour or so, 35 minutes or so, is basically to give you a broad overview of the Cauvery water dispute. And I'll introduce you to some of the hydrogeographic features of the river Cauvery. I'll take you through the history of the dispute. How has the dispute shaped? What are the contentions raised by the parties? And then I'll speak a bit about India and international water law. Basically, I'll take off from where Mohan Kataki sir has left. And from there, I will move on to discuss some of the salient features of the Tribunal award. The Tribunal gave its award in 2007, I guess. Yeah. And then thereafter, in 2018, the Supreme Court gave its final imprimatur to the award given by the Cauvery Water Disputes Tribunal, and the Supreme Court has slightly tweaked with the Tribunal award. So, in what way did international water law influence the decision of the Supreme Court in actually reapportioning the waters, which was decided by the Tribunal? And then I'll give you my concluding thoughts. So this is basically the overall scheme of my presentation. And before I get into my presentation, I must thank Professor Ishwara Bhatt for having invited me to this conference. Professor Bhatt and I share a long-lasting relationship. It goes back to 20 years when Professor Bhatt first invited me to a seminar which he organized while he was the Dean of the Faculty of Law at Mysore University. Since then, whenever Professor Bhatt has ventured into developing scholarship in the area of water law, Professor Bhatt has always involved me in that endeavor. So thank you once again, Professor Bhatt. So now I get down to my business. So as you know, River Cauvery is not merely a river. It is more or less an emotion for both Kannadigas, for Mallus and Tamilians. So if you look at the hydrogeographic features of this river, as most of you might be knowing, it originates at a place called Talakaveri in Karnataka, basically Coorg. Coorg was formerly a princely state, and then finally Coorg merged with the princely state of Mysore, and then, of course, because of the state reorganization and other developments, it became the modern state of Karnataka. So essentially, if you look at the origin of the river Cauvery, it gushes out at a place called Talakaveri. It's in the Western Ghats in a place called Brahmagiri, and this process, it takes place at an elevation of 1,340 meters. And if you look at the most important feature of the river Cauvery is the fact that it's a river that is based in the tropics. So essentially, the primary input with regard to water, as far as the Cauvery is concerned, is from the monsoons. Unlike the northern rivers like the Ganges, the Yamuna. So Ganges and Yamuna, as you all know, it's third standard social studies. We all know that it gets the water from the Himalayas, and the southern rivers get their water from the monsoons. So as far as Cauvery is concerned, there are two important monsoons which actually give it strength. So one is the south-west monsoons, and this happens during a period from June to September. And essentially, if you look at the Cauvery basin, the map of the Cauvery river basin, so what you see is that upward of the Mettur Dam is in Tamil Nadu. So you look at upwards of Mettur Dam, it is primarily influenced. The strength of the Cauvery comes from the southwest monsoon. Now, when you look at downwards of the Mettur Dam, that's the Cauvery Delta, Tanjavur, the area, the Tanjavur, Tiruchinappalli and those areas, right up to the Bay of Bengal, what happens is that the Cauvery gets its strength from the north. From the northeast monsoons. Now, there's a fundamental difference between southwest and northeast monsoons. And the northeast monsoons happens during a period from October to December. So that's when we have the northeast monsoons. So essentially what happens is that the southwest monsoon is more predictable, it's more dependable, it's consistent, it's intense. So Cauvery gets its primary strength from the southwest monsoons. But at the same time, the northeast monsoon is highly unpredictable, okay, and it's unreliable. And more importantly, because of the topography of the Cauvery Delta and the coastal regions of Tamil Nadu, it becomes practically impossible to actually store the water. So if we get rain, courtesy the northeast monsoons, what happens is that the water ultimately joins the Bay of Bengal. So it's very difficult to actually tap and store the water. It's practically impossible to construct dams in that part. So this is actually the basic features of this river. Okay. So this different rainfall patterns, it considerably influences the way in which the water dispute has actually shaped up. So during times of monsoons, you have a river which runs spate, and during times of summer, what happens is that there's no rainfall, and so what happens is that the rainfall, sorry, the water in the Cauvery is just reduced to a trickle, and consequently we have droughts, and then subsequently we have water conflicts. So that is basically the entire structure of the river. And if you look at the length of the river, it's about 800 kilometers. It's 800 kilometers long, and this makes it the fourth longest river in India. And out of this 800 kilometers, nearly 320 kilometers flows through Karnataka, and then it reaches the Tamil Nadu-Karnataka border, where it flows for another 64 kilometers. And thereafter, it enters Tamil Nadu and flows for about 416 kilometers before it enters the Bay of Bengal. So by the time it reaches the Bay of Bengal, it's a small stream. And I think it joins the Bay of Bengal at a place called Pumpuhar in Tamil Nadu. Or Cauvery Patnam. I think it's Cauvery Patnam, yeah. So this is the basic flow of the river, and you have the Cauvery Basin. It's spread about 81,155 kilometers. And if you look at the way in which the Cauvery Basin is organized, it falls within 3 states, namely Karnataka, Tamil Nadu, Kerala, and Pondicherry. And at this juncture, I would like to state to all of you, I would like to bring out an interesting snippet. At one point in time, if you look at the history of the Cauvery River, at one point in time, Cauvery was an international river. And here the contending parties, of course, we have the princely state of Mysore, we have the princely state of Coorg. Coorg was not a very important party, it was primarily the princely state of Mysore. Then we have British India, the British Crown, courtesy the Madras Presidency, and we have the French, courtesy the Union Territory of Pondicherry. So essentially, this is an international river which involved 2 colonial European powers. Okay, so this is how the water dynamics develop. And when you look at this cultivation patterns, primarily what happens is that because of the way in which the geography of the hydrogeography is placed, the primary area which gives maximum productivity is the Cauvery Delta. So, in the Cauvery Delta, paddy is grown. So, rice is the staple food of the people of Tamil Nadu and, of course, Kerala. So, paddy is the main produce in the Delta. And because of it, the importance of the Cauvery Delta in actually producing paddy, it is called the rice bowl of Tamil Nadu. So, it's so important. And mind you, the water required to produce paddy in Tamil Nadu is much less than the water required to produce paddy in Karnataka. So there is that discrepancy as far as the output is concerned. So that is one important point. Now, when we come to the Cauvery Basin, it's home to more than close to about 30-40 million people. Million people. And it supports various hydroelectric projects. There are nearly 15 major hydroelectric projects, 16 major irrigation projects, and more than 42 medium irrigation projects. Of course, the number keeps on increasing. Now, it's an area of intense biodiversity. So we have some unique tourist spots, also eco-important spots, like, for example, the Kuruvadweep Island in Wayanad district. That's in Kerala. And then we have the Bannerghatta National Park. Then we have the Abbey Falls, Catherine Falls. And then we have different places of religious importance. We have so many temples situated on the banks of the river Cauvery. And so in different ways, we can consider Cauvery to be, like I said, it's an emotion. It's the umbilical cord of the people of Karnataka and, of course, Tamil Nadu. And it's the umbilical cord of all the people who live on its banks. So important. And it's an icon of Dravidian culture. So if you look at the ancient Tamil epics, Silappatikaram, there are several verses in the Silappatikaram which eulogize the river Cauvery. Cauvery, in fact, is called Pun in Tamil. Pun means gold. And they refer to Cauvery waters as gold because of its ability to produce or contribute to the production of paddy. Paddy is so important. So this is basically the hydrogeography of the river. Okay. Now I come to the history of the dispute. Now, as far as the history of the dispute is concerned, it goes way back to 2000 years. goes way back 2,000 years. And at that period, of course, the water was being used for irrigation purposes. And during that time, Cauvery, the delta area of Cauvery, the primary place where all agricultural production used to take place, that was called Punal Nadu. Punal Nadu means the land of floods. So this is a place where there was intense flooding. So you can imagine that upstream water was not being diverted in Karnataka. That time, I think it was part of the Hoysala kingdom. Karnataka was actually Hoysala. And then when it comes to Chola land, the water was actually not being used by the Hoysalas to that effect. So the entire water was coming down to the delta and used to create a lot of floods. And this is one of the reasons why Karikala Cholan, in I think sometime in 2nd century AD, I guess, he constructed the Grand Anicut. And the Grand Anicut is still in use in Tamil Nadu, such an important structure as far as irrigation and the Cauvery River is concerned. And occasionally disputes did break out between Hoysala kingdom and Chola kingdom, and there's a book which states that there was a king of the Hoysala dynasty by name Narasimha I, and he blocked the flow of the Cauvery. And because of this, the Chola ruler Rajarajan II, he went for a battle against this ruler of the Hoysala dynasty, defeated the ruler of the Hoysala dynasty, and was able to restore the flow of the river. So these are all historical things. But the basic dimension, the modern dimensions of the dispute emerged with the dethroning of Tipu Sultan. So Tipu Sultan was the ruler of Mysore, the tiger of Mysore. And what happened is that the British in the 4th Anglo-Mysore War, they defeated Tipu Sultan and they reinstated the Wadayar dynasty. So in 1791, the British East India Company entered into an agreement with the Maharaja of Mysore, the Wadayar dynasty. And basically, the Wadayar became a vassal state. Mysore became a vassal state. And the Wadayars were beholden to the British East India Company, the British East India Company, Bahadur. Okay, so that was the situation. So once the Wadayar was reinstated back on the throne, the Mysore throne, what happened is that the Wadayars decided that it was high time that they used the river water of Cauvery to increase productivity in Mysore. So till that time, the primary method used in Mysore to exploit the Cauvery waters was through construction of tanks. There was a lot of, the whole place was peppered with tanks. And nearly 73 TMC of water was actually diverted via tanks to facilitate irrigation. So when the Wadayars came to power, they decided that, okay, we're going to have intensive use of the Cauvery waters. And Mysore began to say that we are the upstream riparian. And what happens is that because we are the upstream riparian, Cauvery originates practically in our territory. So we have a better right. But the problem is they are trying to assert their right against a lower riparian, which is actually the British Crown. By that time, the company had left, and now it's the British Crown which came in place of the company. So the British East India, the British Crown, through Madras Presidency, they began to say that we have prescriptory easementary rights. So we have been using the waters for ages, and till now you are not having plans to use the waters. So our rights, our easementary prescriptive rights, have to be protected. And Mysore came to the position saying that the natural flow, the river originates in our territory, and because a large part of the water was not being utilized, there was unutilized surplus which was actually flowing out into the sea. So what we need to do is, we want to exploit the unused surplus. We want to dam the unused surplus and facilitate irrigation in our territory. But Madras said, no, you can't do it. Even if it is unused surplus, it has to flow because we have prescriptory easementary rights. And that is how the dispute began to snowball. So then what you see is that because of these conflicting positions, both Karnataka and Madras, they entered into an agreement in 1892. And that agreement is basically in the form of rules. So if you look at the 1892 agreement entered into between Mysore and Madras, what you see is that it has got only 6 clauses. And out of these 6 clauses, the essential prescription is that whenever Mysore government wants to construct any new irrigation project or any new reservoir on a list of rivers mentioned in Schedule A to the agreement, what happens is that they have to obtain the prior consent of the Madras government. And Madras government generally cannot refuse consent, but it can refuse consent only to protect its prescriptive rights. And how do you determine your prescriptive rights? It has to be according to the common law principles. And the prescriptive right should be actual and it should be existing. And in case of difference of opinion, the matter will be referred to arbitrators. So soon thereafter, after the 1892 agreements, by 1910, what happened is that Mysore developed plans to construct the Krishnarajasagara Dam. And then they approached the Madras government for permission. Madras government said, we're not going to give you permission. So then there were differences of opinion, finally conflict, and then the matter was referred to arbitration. So a judge from the Allahabad High Court, he was appointed as arbitrator, and he ruled in favor of Mysore. So immediately Madras went in appeal to the government of India. The government of India said, no, we're not going to entertain the appeal. Then it went to the Secretary of State. The Secretary of State said, there is a ground to interfere. So basically what we are seeing here is a vassal state versus the paramount power, the superior power, whereby which whatever rights a vassal state had could naturally claim, that was actually being, it was actually being disrecognized by the superior power, the paramount power. So because of all these differences of opinion, Mysore was again compelled to enter into negotiations with Madras. And by that time, we had the enigmatic Diwan. Diwan was Sri Vishwesharaya, and he was one of the main architects of the modern irrigation system in Karnataka. And finally, they entered into negotiations. And finally, they came up with this 1924 agreement. So this 1924 agreement is basically with regard to the Krishnarajasagara, construction of the Krishnarajasagara Dam in Mysore. So under this agreement, Mysore got the right to construct the Krishnarajasagara Dam, and Madras got the right to construct the Mettur reservoir. So both the two important reservoirs. But if Mysore had to construct the Krishnarajasagara Dam, it had to ensure that the supply, a minimum flow of water, was made available at the upper Anicut in Tamil Nadu. This was one of the conditions in that agreement. Again, as usual, whenever Mysore wanted to construct these projects, it had to provide information to Madras. Of course, there was no reference to prescriptive rights now, but at the same time, it was as if Mysore was given the right to construct the Krishnarajasagara, and Madras obtained the right to construct the Mettur Dam. And this agreement had a shelf life of about 50 years. So it was to be in operation for 50 years. So by 1974, the parties had to revisit the agreement. Now we'll come to that. So from 1924 to 1974, of course, a lot of developments had happened. We saw India's independence. We saw the Indian Independence Act of 1947, the State Reorganization Act. Then Mysore became Karnataka, and certain portions of the Cauvery Basin, particularly two important tributaries of the Cauvery, Kapini and Bhavani, which were originally part of Madras, are now transferred to Kerala. So Kerala became a party to this dispute. And then, of course, we already had Pondicherry and we had Tamil Nadu. So the entire nature of the parties, the dispute began to change. We have new parties. So by 1974, we had new parties. And in the 1960s itself, Karnataka began to initiate certain projects. Karnataka had plans to construct 4 main reservoirs. Tamil Nadu objected to this and said that you are acting in violation of the 1924 agreement, but Karnataka went ahead. And what it did was, it did not obtain the consent of the union government. At the same time, Kerala also had projects, but Kerala went to the union government refused consent, and Kerala did not have the money, so Kerala could not construct the projects. So Karnataka utilized its own funds to construct 4 major projects on Cauvery and its tributaries. So that was the entire sequence of events right up to 1974. So in 1972, just 2 years before the expiry of the 50-year period, Karnataka said, no, there's no question of, again, continuing with these agreements, because these agreements are unconscionable. They are expressions of the doctrine of paramountcy. And of course, they're totally arbitrary and unreasonable. So we are not going to allow the continuation of the agreements. The agreements have expired in 1972. But what happened is that Tamil Nadu said that agreements are not expired. They're more or less permanent in nature. They're more or less permanent in nature. And then there was dispute. But at the same time, in 1972, what we see is that there was a conference initiated by the Union Minister for Power at that time. I think it was Mr. K.L. Rao. Yes, it's Mr. K.L. Rao. And the chief ministers of Karnataka, Andhra Pradesh, Kerala, they participated in the discussions. And finally, they came to the conclusion that we will appoint a Cauvery fact-finding committee. So they appointed a Cauvery fact-finding committee. And the mandate of this fact-finding committee was to study, to procure data regarding water utilization. How is water being utilized? What is the quantity of water available in the river Cauvery? Those kind of things. So the Cauvery fact-finding committee had a very limited mandate. It was not supposed to give any recommendations. It was only supposed to get data. And they did a good job in collecting the data. And based on that data, the parties came to an understanding. And this understanding was actually submitted to the Parliament of India in 1976. But unfortunately, at that time, Tamil Nadu came under the president's rule. And after that, after the period of uncertainty, we had an elected government in Tamil Nadu. And they said that we are not going to ratify this understanding. The understanding is not binding to us. We want Karnataka to abide by the terms of the 1892 and 1924 agreements. And then again, of course, it's a period of uncertainty. So central government tried its best to bring both parties. But of course, nothing happened. And finally, what happened is that in 1986, what we see is that a group of agriculturists in Tanjavur, in Tamil Nadu, they approached the Supreme Court. And they said that the Supreme Court must pass an order directing the central government to constitute a water tribunal to decide the dispute with regard to sharing of the waters of River Cauvery. And then it took another 7 years. So during the 7 years, negotiations were happening, but the negotiations were not at all fruitful. And finally, when the Supreme Court sat down to decide the matter, Karnataka strongly objected. Karnataka said that this particular, we cannot allow this petition because the petition was actually being moved by a private society. So they had no public interest. And then the Supreme Court said, what to do now? Immediately, Tamil Nadu said that we support all the allegations of the put forward by the petitioners. And the Supreme Court felt that the negotiations were going on endlessly and there had to be an end to all this. The Supreme Court asked the views of the central government. Central government said that we are not in favor of continuing with the negotiations because the negotiations are not leading us anywhere. And ultimately, the Supreme Court directed the central government to constitute the tribunal. So this is how the dispute began to flow. And then in 1990, the tribunal was constituted. And its first sitting began, it was on 20th July 1990 that the tribunal was constituted. It began its setting. And the first thing that the tribunal did was, one of the first things the tribunal did was to frame issues. So almost 50 issues were framed and subsequently they were regrouped several times. And finally, we had three main headings for the issues. One was with regard to the validity of the agreements of 1892 and 1924. The second was, what is the quantum of water available in the river Cauvery? And then the third most important aspect is the doctrine of equitable apportionment and related subjects. So 50 issues were grouped under these three broad categories. And then what happened is Tamil Nadu immediately filed, Tamil Nadu and Pondicherry, they filed a petition before the Supreme Court, the tribunal, because the tribunal has been constituted. And once you constitute the tribunal, what happens is that Article 268 comes into operation. The tribunal is constituted on Article 262. Because Article 262 Clause 2 says that once the matter is referred, no court can entertain any petition with regard to the matter that has been referred to the tribunal. So it outs the jurisdiction of courts. That is what Article 262 Clause 2 states. So then what happened is that we have the tribunal and then Tamil Nadu and Pondicherry, they approach the tribunal for interim relief. Because what is happening is that Karnataka was very erratic in releasing the waters. And agriculture in Tamil Nadu was suffering because of that. And so they approached the tribunal for interim relief and stating that at least release 20 TMC of water on an emergency basis. Now, again, Karnataka and Kerala objected this time. joining Karnataka, they both objected, saying that the tribunal has no powers to issue interim reliefs. Then this led to a series of litigation, which was finally decided by the Supreme Court, stating that the tribunal does have the jurisdiction to issue and grant interim relief. And so the ball was pushed back to the court of the tribunal. And what the tribunal did was, it again, if you look at the interim award, you see that the tribunal was slowly hinting at the doctrine of equitable apportionment. But at the same time, it didn't go in that direction because this is only an interim matter. So application of the doctrine of equitable apportionment could happen only at the final stage, not at the interim stage. But nevertheless, what the tribunal did was, it was guided by the principle of balance of convenience, and it wanted to preserve the rights of the parties. And consequently, the tribunal directed Karnataka to release at least 205 TMC of water in 12 installments. And the tribunal specified what quantity of water has to be released in a particular month. So this was basically the interim order. So when the interim order was released by the tribunal, people felt, okay, now we have some sort of at least a short-term solution for this conflict between the two important brothers. But matters took an ugly turn, and riots broke out in Karnataka against the Tamils, and retributive riots broke out in Tamil Nadu against the Kannadigas. So it was almost like that basically at each other's throats. And then what happened is that Karnataka, in a drastic move, it passed an ordinance. It enacted an ordinance called the Karnataka Cauvery Basin Irrigation Protection Ordinance of 1991. And subsequently, the ordinance was replaced with a statute enacted by the Karnataka Legislative Assembly. Now, the basic function of the ordinance was to nullify the effect of the interim award passed by the Cauvery Water Disputes Tribunal. And we have Section 4. Section 4 is critical. So basically, what this ordinance did was to say that notwithstanding any interim order or passed by any court or tribunal, it will have no force. The only order which will have any force is the final order of the tribunal. So they passed this ordinance. And once the ordinance was passed, immediately the President of India referred the ordinance to the Supreme Court for its advisory opinion with regard to the constitutionality of this ordinance. So the matter again now went to the Supreme Court. And the Supreme Court unanimously held that the ordinance was unconstitutional. I think it's a constitution bench which came to the conclusion that the ordinance was unconstitutional. And this ordinance was unconstitutional on several grounds. But the most important aspect of this ordinance is that Karnataka, by passing this ordinance, it sought to take upon itself the role of a judge in its own cause. And more importantly, if you look at this ordinance, the language employed in this ordinance, it is actually a reflection of the Harmon Doctrine. Now, this Harmon Doctrine is actually a discredited principle in international water law. This Harmon Doctrine originated way back in the 1910, during that particular period, in a dispute between the United States and Mexico with regard to water sharing. And I think it was the Advocate General or Attorney General, he came up with this, his name was Harmon, and he came up with this doctrine saying that the US, as the upper riparian, can appropriate all the waters, and we need not be concerned with the lower riparians. And this is exactly what Karnataka sought to do via this ordinance. It was actually basing its stance on this doctrine of propounded by Mr. Harmon. Like I told you, the Harmon Doctrine is a discredited principle in international water law. The stance adopted by Karnataka was more or less reflective of the Harmon Doctrine. And even in the United States, in subsequent water disputes, the United States has disrecognized the doctrine of the Harmon Doctrine. And then what happened is that the Supreme Court struck down this ordinance in toto. And thereafter, the matters went into a limbo. So there was nothing happened. It took almost another 7 years for the central government to frame a particular scheme to implement the interim order. Now, this particular scheme, which the central government framed, it happened in 1998. So the ordinance and the interim order was given in 1991. You understand? And then it took another 7 years for the central government to frame a scheme to actually implement the terms of the interim order. And the scheme framed by the central government, what it did was to provide for the creation of a Cauvery River Authority. And the Cauvery River Authority is a high-powered constitutional body. It is chaired by the Prime Minister of the country, and it had the chief ministers of the concerned states and the Union Territory of Puducherry as members. Along with this, they also had a Cauvery monitoring committee. And the Cauvery Monitoring Committee is an expert body basically created to help the Cauvery River Authority in trying to give effect to the interim order passed by the tribunal and other subsequent orders. That was the basic purpose behind this creation of these two bodies. But of course, matters were not going on the right track. Whenever monsoons failed, Karnataka, of course, had problems in implementing the interim the directions given by the tribunal. And matters would snowball, and of course, ultimately it would lead to rioting and other things. Then this particular impasse continued for a long time, continued till 2007. And finally, on February 5th, 2007, after 580 sittings spread over nearly 16 years, the tribunal gave out its final award. So this is basically the entire dispute in a nutshell. Now, when the tribunal gave out its award, what it did was it determined the total quantity of water in the Cauvery River. And it came to the conclusion that the total quantity of water in the Cauvery River is about 740 TMC of water at 50% dependability. So these are all things matters which are actually the prerogative of hydrologists. So they determine whether it should be 50% or 75%. So if you look at the previous decisions given by water tribunals, most of them have determined the quantity of water in a river based on 75% dependability. But in the Cauvery dispute, they took 50% dependability and came to the conclusion that the total quantity of water in the river would be about 740 TMC. And once they arrived at this figure, the magical figure of 740, they divided the total quantity of water and they allocated 419 TMC of water to Tamil Nadu, 270 TMC of water to Karnataka. Kerala was given about 30 TMC of water and Pondicherry 7 TMC of water. So the total allocation was 726 TMC of water. And apart from that, 10 TMC of water was reserved for environmental purposes and 4 TMC of water as inevitable escape to the sea. So this is basically the formula developed by the Cauvery Water Disputes Tribunal as far as the allocation is concerned. Now, once the tribunal gave its award, again, matters began to snowball. Now, what happened is that Kerala and I think Karnataka and Tamil Nadu, all the three states, they filed appeals, civil appeals against the award given by the tribunal. And because they filed appeals in the Supreme Court, the matter was pending in the Supreme Court. And the union government said that since appeals have been filed against the decision of the tribunal, we are not going to frame any scheme to implement the decision. So the matter was actually kept, it was all snowballed. Then what happened is that the Supreme Court had to intervene. Once again, the Supreme Court had to intervene. And the Supreme Court directed the central government to publish the final decision given by the Cauvery Water Disputes Tribunal. And this happened in 2013. And then again, the dispute continued. And the main dispute now before the Supreme Court was with regard to whether the Supreme Court had the power to decide the civil appeal filed by the state parties. Because under Section 6(2) of the Interstate Water Dispute Act, what it says is that once the award of the tribunal is published in the official gazette, it will have the same force as a decree or order given by the Supreme Court. So you have an award which has got the same force and same force, I won't say sanctity, same force or effect as a Supreme Court order, and that order is actually being placed before the Supreme Court in appeal. Supreme Court had to sit down to judge the validity, the legal validity of correctness of this particular award. Now, this matter was raised before the Supreme Court, and Supreme Court again had to sit down to decide whether the appeal was maintainable. The Supreme Court came to the conclusion that Supreme Court did have jurisdiction to hear the appeals filed by the states against the final award given by the Cauvery Water Disputes Tribunal. And this happened in 2016. Essentially, by 2016, it paved the way for the final decision of the Supreme Court. And in 2000 February, the Supreme Court gave its final imprimatur to the Cauvery Water Dispute, in the Cauvery Water Dispute Tribunal. It passed its judgment, and the judgment practically upheld the award given by the Cauvery Water Disputes Tribunal. But of course, certain modifications were made. And the decision was given by Honorable Justice Deepak Mishra in 2018. So, the most important thing that you must understand is that this water apportionment formula, which was actually approved by the Supreme Court or created by the Supreme Court to a certain extent, this water apportionment formula will hold the ground for the next 15 years. After that, it can begin re-examined in light of experience gained in others. So this is basically the broad history of the dispute. So now you have a basic understanding about the river and its features, and you have a basic understanding about the history of the dispute. Now I'll come to the third part of my presentation, that is about India and international water law. Now already Mohan Kataki sir has already spoken about it, and Professor Hegde has also dealt with India and its approach to international water law in great detail. So I'll just give a broad, certain basic points from this section. So as you know, international water law, we have two important instruments. One is the Helsinki Rules of 1966. The Helsinki Rules was developed by the International Law Association, and the heart of this instrument is Article 4, Article 5. I think it's already been explained. Article 4 talks about the doctrine of equitable apportionment, and Article 5 specifies 11 elements that need to be considered as a whole while apportioning the waters, while equitably apportioning the waters. Now, the Helsinki rules, there have been subsequent revisions. So we have the Campion Consolidation of 2000 and finally the Berlin Rules of 2004. And the Berlin Rules, it has been said that it represents customary international law. So that is basically the Helsinki Rules. And then we have the UN Watercourses Convention, which was adopted in 1997. So if you look at the UN Watercourses Convention of 1997, it's a hard law instrument. And this instrument, 106 countries voted in favor of this instrument. 3 countries opposed. One is China. It's very important for us because China is the upper riparian as far as most of our international rivers are concerned. There were 26 abstentions. India was one of the countries who abstained from voting as far as this convention was concerned. And it took 17 years for the convention to come into force, and only 37 parties it has. And majority of the parties are European countries. None of the South Asian countries have ratified the UN Watercourses Convention. And India has not ratified. India abstained from voting for the convention. And India has got some reservations with regard to certain articles in the convention. So what I'm saying here is that we have 2 important instruments. One is a binding hard law treaty which has come into force. That is the 1997 UN Watercourses Convention. India has not ratified it, but at the same time, we have a soft law instrument. Soft law instrument does not impose any binding obligations. So it becomes much more easier for countries to actually adapt soft law instruments. And that is what we see as far as the water tribunals and water disputes in India is concerned. Because since India has not ratified the UN Watercourses Convention, the tribunals are a bit handicapped as far as referring to the UN Watercourses Convention is concerned. But they have no fetters as far as the Helsinki rules are concerned. They have, because it's soft law, they can actually apply them malleable. The principles are malleable, and they can apply the principles according to the unique national context. So this is what we have to understand as far as the UN Watercourses Convention and the Helsinki rules is concerned. So like I said, India prefers the Helsinki rules. There are no binding obligations. Almost all our water tribunals, the Godavari, the Mahadayi, and more importantly, the Cauvery Water Disputes Tribunal has specifically referred to the Helsinki rules. The Supreme Court of India has also given a stamp of approval to the Helsinki rules. Now, at this juncture, I would like to, you to just be reminded of the case Vichaka was the state of Rajasthan, which actually dealt with the doctrine of incorporation and other things. So in one particular way, we can say that in the Cauvery water dispute litigation, the Supreme Court was actually trying to incorporate, at least to a certain extent, Helsinki rules into domestic law. Now we come to the tribunal's decision and Supreme Court award. Now, as far as the tribunal decision and Supreme Court award is concerned, I am mainly concerned with the most important crux of this decision, because we already know that the tribunal spent I don't know if you have gone through the tribunal report. It's in 3 volumes, and the tribunal elaborately mentions about the principles, how it came to the conclusion that the water in the Cauvery is 740 TMC at 50% dependability. There is one particular volume which speaks in great detail about the principles of apportionment. Sorry, the report of the Cauvery Tribunal is in 5 volumes. It's a classic piece of work. Now, the most important aspect that we need to consider is what is the principle of allocation that the Supreme Court also referred to. Now, in this context, we all know that definitely it would be the equitable apportionment doctrine. And we also know that Karnataka was more or less in favor of the Harmon doctrine, at least adopting a stance similar to the Harmon doctrine. And Tamil Nadu was more or less on prescriptive easpentary rights. And both these doctrines are discredited in international water law. And then we have this principle of equitable apportionment. So even prior to the Supreme Court sitting down in the Cauvery pattern in 2018, when the Supreme Court sat down to decide the constitutional validity of the ordinance, it had clearly stated that the waters of an interstate river, they are a national asset, and no single state can claim exclusive ownership. So already the Supreme Court was in favor of the doctrine of equitable apportionment. And when you look at the award of the tribunal, you will see that the tribunal is referring every now and then to the Helsinki rules. So it rejected all other principles and said that Helsinki rules or the equitable apportionment doctrine as enshrined in the Helsinki rules was the correct touchstone that should be used to determine the water allocation in this particular dispute. And the Supreme Court, when it got its opportunity, it said that the tribunal was absolutely correct in referring to the principle of equitable apportionment. And the Supreme Court said that if the Helsinki rules, they are actually applicable to an international drainage basin. And these principles enshrined in the Helsinki rules can also be applied to an interstate river water dispute. So this brings us back to the doctrine of incorporation, as enunciated in several cases, including Vishaka versus State of Rajasthan. Now, Supreme Court even referred to Helsinki rules as functional dynamics that helps us in equitably distributing the waters of an interstate river. So that was the importance given by the Supreme Court to Helsinki rules. And if you look at the 11 parameters identified in Article 5 of the Helsinki rules, we have Clause 8, which talks about availability of other resources. Now, one important point which came up before the tribunal was, should groundwater be included as an additional source while equitably apportioning the waters? Now, Tamil Nadu always made an argument saying that, of course, we have groundwater under the delta, but this groundwater is basically the water that has been released from the Mettur Dam. So it is, in other words, it is part of Cauvery water. But at the same time, there was evidence, even Tamil Nadu's pleadings, it all pointed to the fact that there was a source, a groundwater source. Of course, the source could actually be rainfall, and through percolation, it would have become groundwater. So there was an additional source, not just the release from the Mettur Dam, it also percolates into the ground. So the tribunal came to the conclusion that there was some quantity of groundwater that is available independent of what was being released from Mettur and what would percolate and infiltrate into the ground. And the Supreme Court also agreed with what the tribunal found. But the tribunal stopped at that. The tribunal said that there is some quantity of water, groundwater, that is available independent of the Cauvery River in the Cauvery Delta. But the Supreme Court went ahead and said that that water should be included as far as deciding the shares of the different states are concerned. So when you're apportioning the waters, you can actually include groundwater. If you look at the previous decisions given by other water tribunals, they have also said that groundwater is a factor that we need to consider. But they were also handicapped because they didn't know how to scientifically compute. There was no data available in front of them. But the Supreme Court, based on whatever evidence was provided to the parties, it came to the conclusion that at least 10 TMC of groundwater can be safely included in the final allocation of Cauvery waters. And that is how the Supreme Court actually incorporated groundwater as an additional factor that should be taken into consideration when we equitably apportion the resource. So that is very important, that finding. And this finding came mainly because of principle clause article 5 clause 8 of the Helsinki rules. So that is one important aspect that we need to consider. Then of course it went another important dimension or another important feature of the award is that both the tribunal and the Supreme Court said that you have to set apart a certain quantity of water to ensure that environmental purity of the river Cauvery is mentioned. And the Supreme Court even goes on to use the word environmental morality. As part of environmental morality, as part of the need to prevent pollution of the river, we need to set apart a certain quantity of water. And the tribunal had already done that. Tribunal had allocated 10 TMC of water, and the Supreme Court affirmed that allocation. So ultimately, what it did was it reduced the share of Tamil Nadu, because Tamil Nadu had 10 TMC of groundwater available to it that could be safely used in the final computation. So it reduced 10 TMC of water. And taking into account the fact that Karnataka has suffered historical injustice, what it did was it further reduced another 4.75 TMC of water from the Tamil Nadu share and granted that to Karnataka. So in one way, the Supreme Court was actually trying to effectuate a balance, trying to take into consideration the historical injustices that have been perpetuated on Karnataka by a colonial power. And in that sense, it reduced 14.75 TMC of water from Tamil Nadu share and gave that water to Karnataka, out of which 4.75 TMC of water was actually to be used to cater to Bangalore's drinking water requirements. Because by now you all know that Bangalore has become an international mega global city, and catered to the water requirements of Bangalore, 4.75 TMC of water was allocated to Karnataka. So this is the final allocation. So what we see is that the share of Tamil Nadu was reduced a bit, primarily because Tamil Nadu had groundwater which could be safely included in this computation. And more importantly, 4.75 was given to Bangalore. And in this regard, it seems that the Supreme Court was considerably influenced by the doctrine of equitable apportionment. So what I'm trying to say here is that when we look at the Interstate Groundwater Disputes Act of 1956, we find that there is no principle in that particular statute as to how tribunals should decide interstate river water disputes. It's a procedural statute. It provides the constitution of a tribunal. It provides power to frame schemes. But apart from that, what should be the principle that tribunals should rely to when they decide a question relating to equitable apportionment? So that particular principle has not been mentioned. And here, it is in this context that we must appreciate the decision of the Supreme Court in this Cauvery matter, because the Supreme Court has practically incorporated the doctrine of equitable apportionment as enunciated in the Helsinki rules as part of our domestic law. So, in final conclusion, what we see is that we have an upper riparian state basing its claim almost on the doctrine of Harmon, what Harmon propounded, and then we have a lower riparian state which is basing its claims on prescriptive easpentary rights. And of course, the Supreme Court, as a guardian of the Constitution and the federal nature of India's polity, it brought in the principle of equitable apportionment. And in this context, it was guided by what was stated in the Helsinki rules, because it was soft law, it was more malleable, and it was more easy to incorporate the principle into India's domestic law. So, in final conclusion, what I want to state is that it's high time that I think that the government of India is planning to amend the Interstate Water Disputes Act, and it would be a very good idea if we actually incorporate the principle of equitable apportionment, give it some form of statutory basis, so that future tribunals and future courts would have some proper guidance as far as how interstate water disputes will have to be resolved. Thank you very much. Yes, I'm done.
Thank you, sir. Do we have any questions? I'm immensely thankful to Dr. Puthucheral. I thank you, sir, for making time from your busy schedule to provide your valuable insights for our today's national webinar. Your own ideas and the way of explanation of the topic gave us a much needed elevation. Thank you, sir.
Just 1 second, I wanted to make a correction because Mohan Kataki sir just wrote to me saying that Coorg was not a princely state. It was part of British India as Chief Commissioner, Province of Coorg. So I stand corrected to that extent. Okay. Thank you, sir. Thank you very much. I don't know whether Mohan Kataki sir is there, but I just wanted to mention it. Thank you very much. And once again, thank you, Professor Bhatt, for inviting me. And I hope do you have any questions? I'm okay to take questions if you have.
Tony, one more small correction.
Yes, sir.
Vishweshwaraya was not the Diwan when 1924 agreement was entered into.
Okay,
He was
sir.
Diwan before 1918.
Okay, sir. Okay.
So the 1921 agreement and 24 were under the Diwan called Banerjee.
Banerjee. Okay, sir. Thank you, sir. Again, I stand corrected.
Otherwise, excellent presentation.
Oh, thank you.
An opportunity to recollect our own case.
Oh, thank you, sir. Thank you, sir.
Thank you, Tony George.
Thank you, sir. Thank you. Thank you.
Thank you, sir. Requesting Rashita to take over the session to introduce our esteemed Vice Chancellor, Professor Dr. Ishwar Bhatt.
Thank you, Serene. It is indeed a great honor and privilege to introduce Professor Dr. P. Ishwar Bhatt. Professor Dr. P. Ishwar Bhatt is the Vice Chancellor of the Karnataka State Law University, Hubli. He holds a PhD from the University of Mysore and an LLD from the National Law School of India University. He has more than 40 years of teaching experience. Dr. Bhatt has served as the Acting Vice Chancellor for the University of Mysore and Vice Chancellor of the West Bengal National University of Juridical Sciences. He handled 5 research projects and has guided 21 PhD candidates. His specialization is in constitution law and has taught constitution law, administrative law, law and social transformation, non-profit law, legal research methodology, intellectual property rights and water law. He was a Fulbright Nehru Visiting Fellow, Shastri Visiting Lecturer, Salzburg Fellow, and a Shastri Research Faculty Awardee. Dr. Bhatt has to his credit the publication of 130 research articles in reputed national and international journals. He authored books on idea and methods of legal research, non-profit voluntary organization law, law and social transformation, fundamental rights. He has also edited books under the title Essay in Law, Constitutionalism and Constitutional Pluralism, International and Interstate Water Disputes, and Water Natural Resources Law. Given his contribution to legal knowledge, he was honored with the Professor Upendra Bakshi National Award for Legal Research in the year 2020. Sir, I kindly request you to deliver your lecture on elements of equity, ecology, and development with justice in Mahadai Tribunal's report, A Critical Study. Please, sir.
Thank you. Shri Mohan Kataki, Dr. Tony George, Professor V.G. Hegde, all the faculty members, the resource persons, dignitaries, students, and invitees. It gives me great pleasure in participating by contributing one paper on elements of ecology, equity, and development with the justice in the Mahadai Tribunal's decision on interstate water dispute, a critical study.
As you are aware, rivers, watersheds, and aquatic ecosystems are the biological engines of the planet. Rivers contribute very, very significantly to the social, economic, cultural life of the nation, or culture of the basin. All the residents of that basin, all the living beings living in that basin depend upon that river. The emotional attachment, the economic interests, and various other factors establish a kind of link between people of that basin and the river. That's why there is an effort of identifying the interest of legal personality in a river itself. Bracketing of various interests, sometimes conflicting, sometimes collective interests, in such a way that the people of that basin as a whole can be represented through that river. That is one idea with which that legal personality is built up. There are several theories about a legal personality. There is a bracket theory, fiction theory, purpose theory, concession theory, interest theory, and a number of theories are there. But most interesting or most appropriate theory that comes to our analysis is the theory of bracketing of interest. Several interests are to be identified, and of course, insofar as rivers like Mahadayi, it is essential to take into consideration all those factors. Mahadayi is a special river. It is just 111 kilometers long, and its basin is not that big, just 2032 square kilometers, out of which 375 square kilometers in Karnataka, then 77 square kilometers in Maharashtra, and the rest in Goa. The picturesque scenario of Mahadayi, starting from Kanapur to Panaji, it's a very beautiful journey. Cascading waterfalls, curves, mountains, and flora and fauna, rich biodiversity. All these factors make the basin quite special. I am focusing on the aspects of ecology, equity, and development with the justice. According to me, Mahadayi Tribunal Award, which was given on 14th August 2018 and notified after 20th February 2020, is more a decision favoring ecology, and it is not that much favoring the idea of equitable apportionment, or even the notion of development with justice. In order to elaborate, let me share the screen. I request Akila to
Yes.
Please arrange for that. Yes, next. Mahadayi is at the threshold of a nascent stage of development. Shri Mohan Kataki was arguing on behalf of Karnataka, pointing out that it is least developed or developing. If not, it is a virgin. Only 5% of the natural resources, 5% of the basin is developed. That's why the principle that is to be applied is something different from the principle that could be applied insofar as the developed river basin is concerned. Colorado case and various other cases, they are governing the well-developed river basins, whereas this is not well-developed at all. During last 30 years, there has been dispute about the extent of diversion that could be made by state of Karnataka, because in Karnataka, the Malaprabha river is not providing adequate resource or adequate irrigation facility or adequate drinking water to the people of North Karnataka. With a lot of ambition, that project was made, and post-project developments do not show that there is a development of the catchment area. It is through afforestation, development of tanks and natural resources that the catchment area is to be developed. Otherwise, the catchment area becomes quite dry, and it will not be serving the purpose. There are certain scientists who complain that the post-Malaprabha project developments relating to greening of the earth is not that satisfactory. That's why there is a inherent failure on the part of people of Karnataka or Karnataka government to develop a rich natural resource in Malaprabha basin, whatever it may be. There is a big crisis in a supply of drinking water at various cities of North Karnataka, especially Belgaum, Gadag, or of course Hubli Dharwad and various other places. In Hubli Dharwad, sometimes during summer, once in 10 days, that water is supplied, water is not adequate. It has a population of about 9 lakhs, but still the government is, the corporation is not able to provide adequate supply of water. Are there any alternative sources for drinking water for Hubli Dharwad? About this also there was a discussion in the Madai decision. We find that some tank was abandoned, that Kalgat tank was abandoned, and of course Unkal Lake is not helping, and other resources are not adequate. Now, please go to the next one. Yes, profile of Madai is such that the total quantity of water available is 188 TMC, and Karnataka's contribution is to the extent of 32.11 TMC. That's the water availability in a Madai basin of Karnataka region. It is 32.11 TMC, whereas Maharashtra has a small share of 7.21 TMC. Please go to the next. This is the map which shows the
tells us how it should be amended. It does not impose any limit to its amendability. And yet the learned judges of the Court of Appeal are in agreement, erroneously we submit, with the High Court that the basic structure of the Constitution is amendable only through the primary constituent power, which must include full separation.
And there is some disturbance. There is some disturbance. Oh, okay.
Yes, sir.
Please
We
go to the
have
next one.
asked.
Please go to the next one. genesis of the dispute is traceable to farmers' demand in the 1980s, where a scarcity of drinking water was experienced. The then Chief Minister, Sri R. Gundu Rao, constituted one committee headed by Sri S.R. Bommai. In 1989, there was a meeting of Chief Ministers of Karnataka and Goa, and Chief Minister of Karnataka proposed to have diversion of water from Madai River to Malaprabha Basin. The Bommai committee had also earlier proposed about filling the Navil Tirtha reservoir by diverting water from Madai, so that the people will be getting more water for irrigation, for drinking purpose, and such purposes. In 1989, the Chief Minister of Karnataka promised that, or he proposed that the construction of a dam at Kalasa and Banduri will be providing some opportunity to divert Madai water to Malaprabha Basin. And he assured to state government of Goa that there will be continuous flow of water during the summer, which otherwise would not have been available, because Madai is primarily a seasonal river, and during the summer it is empty, and availability of 1.5 TMC of water continuously will be helping the ecology of Goa. That was the assurance. In 1992, Interstate high-level meeting was held, and Karnataka proposed that there shall be diversion of 9 TMC of water to Malaprabha, and use of 20 TMC for power generation, and a release of 1 TMC per month to Goa during the lean season. And technical committees were constituted. References were made to NERI and CWC. There's a National Environmental and Engineering Research Institute and Central Water Commission. In 1996, meeting of irrigation ministers took place, and there was a consensus for a diversion of 3.34 TMC to Malaprabha and 1.5 TMC for a Mandavi project. This is a very important development at the level of irrigation ministers, and at the level of cabinet ministers. There was that understanding that by permitting diversion of 3.34 TMC of water to Malaprabha Basin, the problem of Karnataka could be resolved, especially the scarcity relating to drinking water could be resolved by such a diversion. In fact, 3.34 TMC of water is something coming nearer to the ultimate permission given by the Madai Water Dispute Tribunal in 2018, because it's a 3.9 TMC of water that's allowed for such a diversion. But in 1996, on the basis of a consensus, 3.34 TMC was allowed, but it did not materialize because the government of Goa went for a litigation rather than a negotiation. Negotiation and settlement, conciliation, these are the alternative modes of a dispute settlement under a Interstate Water Dispute Act. Today, there was a very good discussion about the provisions of Interstate Water Dispute Act, both by Sri Mohan Kataki and by Dr. Tony George, that it is a procedure. It only lays down the method of resolving the dispute, and it does not speak about the substantial principle. Even about the procedure, there are alternative procedures, and only when the central government is convinced about the futility of continuing a negotiation effort, that it can constitute a tribunal, and quasi-judicial adjudication will take place accordingly. What I intend to emphasize is that if the path of a negotiation had been pursued, the position would have been a bit different, and there would have been early resolution of such a dispute. Even Madai Tribunal points out that the political issues and water management problems should have been resolved by amicable approach, and when political representatives, bureaucrats, and management engineers, water management engineers meet, many times the legal issues are simply skipped, and what could have been resolved by addressing those legal issues could not be properly carried out, and that's why there was such error. And today, when our Honorable Chief Minister says that Interstate Water Disputes Act has failed in providing remedies because of a delay that is involved. See, that approach of a consensus which could have provided some solution that took place in 1996, and after a period of 20 years, Karnataka is getting just 3.9 TMC of water for diversion. Of course, 1.5 TMC for in-basin use for drinking and irrigation purpose. That's in Mahadai Basin of Karnataka region. But the net result is that after waiting for a period of 20 years, we did not get adequately. There was a deviation from the principle of development with justice. About that I will point out later. Neary had reported in 1998 that there could be diversion of 9 TMC of water in addition to utilization under Madai hydroelectric project. It was a bit generous, and of course in 2002 there was an interstate meeting under the aegis of Central Water Commission. Central Water Commission gave Karnataka in principle clearance from a water availability angle to divert 7.56 TMC of water from monsoon flows to utilize for the purpose of drinking water needs of Hubli Dharwad. That's a very important step that was taken. That was also a very good proposition. If 7.56 TMC of water had been agreed by Goa in 2002 itself, the matter would have been settled in a very amicable manner, and Karnataka could have gained quite satisfactorily. But it did not take place because Goa objected against this in principle clearance. It argued that CWC did not take into consideration various interests in Goa. That's why there was this kind of problem. Of course, about this issue, the matter was taken to the Supreme Court in 2006 by Goa. Meanwhile, there were negotiations And in 2010, the central government considered that it is not possible to resolve the dispute through negotiation and settlement, and ultimately it went for a formation of this Mahadai Water Dispute Tribunal. About the Kalasa Banduri Nala, let me illustrate by taking you to the map. Please go to the earlier slide. Akila, please go to the earlier slide.
Yes.
The map.
Yes.
See, this is the map of the northern or the upper area of Mahadai River. Mahadai River is constituting a basin different from a Malaprabha basin. Between the two, there is not much distance, but basins are different. Malaprabha water is flowing towards east, whereas Mahadai water flows towards the west. And there are certain tributaries joining Mahadai River from Karnataka. And Kalasa Nala and Banduri Nala are the two nalas which could be used for a transfer of Mahadai water to Malaprabha Basin. See, this is a kind of inter-basin transfer. Inter-basin transfer is not something unscientific. It is not against nature also. Although Goa has argued that it is against nature, and it is going against the true principle of autonomy on the part of river basin, etc. But there is no such thing. We have come to the edge of networking of rivers. Yesterday, Dr. Avdesh Pratap has pointed out how interlinking of various rivers in North India took place, and it is an ongoing phenomenon. Both at Kalasa and Banduri, and some other points also. If Nala could be built up and water could be diverted without much difficulty, then there is no damage to ecology. See, the area that is submerged is not substantial. Further, the water that is stored in those nalas will be benefiting number of ecological reasons. That will help the whole river basin. Yes, about the ecological arguments which are put forward by Goa against this particular diversion, we have to examine. Please go to the next slide. Next. Yes, of course. This slide speaks about the formation of the tribunal headed by Justice Panchal, a former judge of Supreme Court, and other two judges were Justice Vinay Mittal and Justice P.S. Narayana, and the whole of the work started on August 21st, 2013, and the final decision came on 14th August 2018. Then there was a delay in notification of the decision. Then, of course, Maharashtra approached the Supreme Court and got the order for notification. And of course, there is a failure of a negotiation, and ultimately through adjudication that the matter is settled. Yes, please go to the next one. The argument from the state of Goa about ecology. Yes. Next slide. Yes, it starts with this approach that Western Ghats constitute one of the world's hottest hotspots of biodiversity. It's viewed in a Kasturirangan committee report that management of Western Ghats ecology involves conservation, protection, and rejuvenation, as well as a sustainable development in the Western Ghats through periodical assessment of environment and ecology on a long-term basis. Yes, it is essential to know that whole of Mahadai Basin is rich in flora, fauna, and it is having as many as 5 wildlife sanctuaries and 1 bird sanctuary, and the diversity of species in fishes. All these factors are pointing out that unlike other rivers, Mahadai River is something different, because each river has its own identity, it has its own personality, and insofar as Mahadai is concerned, because of the rich biodiversity, its position stands in a different footing. Yes, first argument is that the very idea of interbasin transfer is opposed to nature. Then impact of global warming. Because of global warming, there is a rise in the sea level, expansion of saline water boundaries. Because of that, if there is a depletion in water flow in a Mahadai River, then it will cause further deterioration in the health of that river. Then proposed diversion schemes of the states of Karnataka and Maharashtra would severely result in destruction, exploitation, damage, and diversion of habitat from the wildlife sanctuary. See, about wildlife sanctuary and diversity in flora and fauna, it is pointed out by Goa that yes, the proposed projects are likely to destroy permanently an area rich in biodiversity, which ranks second in India after Sundarbans, and is in the 153rd world as the finest tiger habitat, and is home to many species of flora and fauna, including endangered rotten free-tailed bat and Theobald's tom bat. It is maintained that Barapedi caves in Mahadai Valley is the only place where Rotten's free-tailed bat is found in the whole world, and Theobald's tom's bat is also rare. This points out how the ecology-based arguments are quite persuasive. Then decrease in natural flow of water will degrade the groundwater flow in a Goa basin. Then non-compliance with the requirement of getting a environment impact assessment clearance by Karnataka is bad in law, and there is a violation of Article 21. Environmental flows shall be given a priority, and sharing of water shall be subject to the same. There's it was insisted upon the tribunal that the tribunal shall identify the safe environmental flow that should be allowed in Mahadai, and any type of apportionment should be subject to this requirement that safe environmental flow shall be allowed. Karnataka countered in this way that assessment of damage to environment is to be calculated in accordance with the environmental legal regime, and Goa has not established on the basis of convincing scientific data about the impact of projects on wildlife sanctuaries. Yes, please go to the next. The factor of principle of equitable apportionment. In fact, equitable apportionment principle, which is accepted by Madai Tribunal also, is a well-established principle from a Indus commission to the present that development has taken place. But the problem faced by Madai Tribunal was this. There was a total absence of adequate scientific data produced either by state government of Goa or even produced by Karnataka to prove that the water available in the basin could be quantified in a very precise manner. So about quantification of the water available, there was inadequate data. Further, there was a lack of scientific data about the damage that would occur upon the wildlife sanctuaries, upon ecology, upon fisheries, or upon navigation. About all those things, scientific data was not available. In the absence of all this scientific data, the tribunal had to give a very incomplete decision. Madai Tribunal's decision should be regarded as an inchoate decision or incomplete decision because of lack of adequate data. Please go to the next one. That is why apportionment did not take place. However, for the purpose of decision of the case, the tribunal quantified the water availability as 188.06 TMC, and Karnataka's share is 32.11, Maharashtra 7.21. Then, since data furnished was totally inadequate, apportionment had not taken place. It was not a case of apportionment of water in accordance with any specific principle. But in order to meet the requirements of drinking water or human rights or human needs, some policy, some decision of making water available was provided. Thus, we consider that primarily this is an inchoate decision. The apportionment made to Karnataka is as follows. There's an allocation of 1.5 TMC for in-basin consumptive use for drinking and irrigation within Madai Basin. Then permission to Karnataka to divert Madai water to the extent of 2.18 TMC at Bandura and 1.72 TMC at Kalasa. Permission was also given to undertake a hydroelectric project at Kotni by making a non-consumptive use of 8.02 TMC. The claim of Karnataka for a diversion of 5.55 TMC of Madai water to Supa Dam was rejected. Additional demand for 7 TMC at Kotni for a hydroelectric project was also rejected. Then it was insisted that environmental clearance and detailed project reports approved by technical committees of CWC shall be there before launching any of such projects or before going ahead with the project. Yes, please go to the next. So far as Maharashtra is concerned, its entitlement is as follows. Allocation of 0.56 TMC for a consumptive use under Virdi minor irrigation project, and permission for launching of 4 proposed minor research projects, minor irrigation projects to the tune of 0.77 TMC. Then regarding Goa, Tribunal considered all the proposed 59 projects as on a positive direction, and the Tribunal allocated 24 TMC for all these projects put together. This is in addition to the existing utilization of 9.395 TMC by Goa. About non-consumptive use of water in Madai Basin by Goa, no restriction was imposed. Yes, please go to the next. Some critical observations can be made about Madai Tribunal Award. First, there was a low-key treatment of development with the justice. Development with the justice is a very important principle under Article 39B and 39C of the Constitution, and also Article 38 Clause 1 and 2. There is a economic justice or regional parity and various other factors, so that the communities living in different areas will be having access to economic resources in an equitable manner. This idea of development with justice should have been made part and parcel of equitable apportionment principle. Of course, this was not adequately done. And in a Madai Tribunal itself, the idea of economic development of the whole basin of Madai or basin of Malaprabha by taking water from Madai was not adopted. Karnataka has a serious problems relating to water, either for irrigation or drinking purpose. There is a need to consider that this notion of development with justice shall be center stage in the course of decision making. Second observation is this: the report or decision of this tribunal is primarily inchoate, as it did not decide many important issues by pleading inadequacy of scientific data. Of course, what best that was done was giving a benefit of doubt to ecology, but it was at the cost of equitable apportionment and even development with the justice. And Karnataka is the sufferer because of that. Then ecological factor dominated in the decision-making process. See, the report's analysis of the ecological arguments and the final conclusion that is arrived at concerning ecology, that exhibits strong inclination of the tribunal in favor of protection of ecology. In most of the Supreme Court judgments or tribunal decisions, we find that it is either a balanced approach between ecology and development. A balance is struck. Sometimes it is a development that is preferred. For example, Narmada Tribunal Award, it is inclined towards the promotion of development, and many of the environmental lawyers or environmentalists have criticized that judgment for the reason that development is preferred at the cost of environment. But here, it is an environment that is preferred at the cost of development. That the rivers of Narmada can be found in this particular tribunal's approach. Then what was originally agreed by irrigation ministers in 1996 was a permission to Karnataka to divert 3.34 TMC, which after 22 years of dispute and litigation got marginally modified into 3.9 TMC by award of this Madai Tribunal. It's a very marginal gain, and for a period of 20 years relating to irrigation, relating to supply of drinking water, or relating to the development of the basin, Karnataka had suffered, and litigation did not provide immediate remedy at all. Yes, national water policy and environmental policy recognize interbasin transfers. Networking of rivers has come to stay as a major policy. Thus, the basic approach should be towards a more balanced approach With this, let me conclude. Thank you very much.
Thank you, sir, for sharing your precious words and ideas on elements of equity, ecology, and development with justice in Mahadai Tribunal's decision, a critical study of Mahadai and genesis of dispute, principle of equitable apportionment, and critical observation. Thank you, sir. I request Ms. Yashita Desai, student of KSLU, to kindly introduce our next resource person, Dr. Sujit Kunan.
Very pleasant afternoon to one and all present here. I'm Yashita, and it is both an honor and my privilege to be able to introduce Dr. Sujit Kunan. Dr. Sujit Kunan is an assistant professor at the Faculty of Law, University of Delhi. He obtained his PhD from the SOAS University in London. Dr. Kunan pursued his LLM from the Kochi University of Science and Technology. He also holds an MPhil in Public International Law from the Jawaharlal Nehru University. He is a member of the editorial board of Law, Environment and Development Journal. Dr. Kunan's main areas of interest are environmental law, water and sanitization, natural resource law, human rights, international law, and agrobiodiversity. He has published widely. Some of his most recent works include Manual Scavenging in India by the Indian Law Review in 2021, as well as Research Handbook on Law, Environment, and the Global South. He also shared some critical perspectives in the Oxford University Press 2019 on the topic Right to Sanitization in India. I would now like to request Dr. Kunan to share his valuable insights on the topic Challenging Water Inequity and Injustice, Role of Social Movements. Over to you, sir.
Thank you, Ms. Yashita, for that introduction. Yeah, and I think, thank you, the organizers, for again, bringing up water issues and giving me this opportunity to share some of my thoughts. I think, I must apologize for two reasons. And first come first, I may be delaying your lunch. And the second thing is, although this whole program is primarily focused on Karnataka, and I must apologize that I won't be bringing any Karnataka specific aspect in what I'm going to tell you. However, I believe that the core aspects of what I'm going to discuss might have some kind of importance, not just to Karnataka, all states, and particularly of those who are interested in water, natural resources generally. So yeah, with that footnote, let me start. What I'm going to talk about is some of the inequity or injustice related issues, and by taking social movements as a starting point. And in order to start with, or in order to provide a broad context of what I'm going to talk about, let me use a very interesting, in fact, two interesting books published, one in 2002 and the other in 2005. And one was written by an activist scientist from India, Vandana Siva. And the other one, and the title of the book is Water Wars. And the other book, written by, again, two activists from Canada. And the title of the book is Blue Gold. And why I'm starting with these two books is, one, both have some kind of interesting thread in order to start this debate about water inequity, injustice, and role of social movements. Because this book, among many other books, there are quite a number of, numerous literature covering this issue. However, these two books, it provides a kind of a central thread, and that is, it talks about shifting of power from community and in certain cases state to corporates as far as natural resources are concerned. And it also talks about this shifting of power shifting of power and control over natural resources, including water, It also talks about the larger political context where these kinds of shifting is facilitated by international organizations, international law, and their domestic counterparts. For instance, including domestic legal system. So law, legal system or legal framework together, it facilitates that kind of shift where some of these natural resources were under the control of state or under the control of community, and now slowly being shifted under the control of big multinational corporations. And that was broadly an important thread developed by these two books. So that takes us to an important question, particularly from a legal perspective, is that, so what? What is the problem in it? Why should it be under the control of community? Or why should it be under the control of state? What is the problem in keeping it under the control of corporations? And if at all, they are doing it, if at all this policy is being developed, then isn't it because that, the states, sovereign states, have permitted it? And of course, technically speaking, these things are being implemented with the will of the state, no doubt about it. But that is a very technical view. And if we try to pose further questions, so we might need to rephrase the question saying that, okay, of course it happens with the will of the state. Then the question is whose will, or let me put it in this way, whose will is represented by the state? For instance, we can all ask ourselves, like, okay, whether my interest or my community's interest, my society's interest are represented in the state's will or not. Because there is a theory that state represents everyone. And I'm sure, I think many of us would refuse to believe that. Because many a times, we know that the system does not reflect everybody's will, everybody's interest, and everybody's concern. So that takes us to a very interesting critical theory, and that is, in most of the cases, these developments that reflect the interest and concerns of certain groups, and those groups in critical literature are generally called as those are the elites. And some scholars, have coined a very interesting, beautiful terminology, and they call it as transnational capitalist class. Transnational capitalist class means it is like a class that transcends, that straddles. You don't keep them at the domestic level. You don't keep them at the international level. They are like, they're present everywhere. And why I'm saying all this story, sometimes ambiguous, sometimes seemingly abstract. The point is, there is, what is the basis? And okay, for these kinds of dominating policies, there seems to be a counter movement. And that counter movement is where the space where social movements are relevant. Because one of the ways in which social movements have dominated or kind of, showed their potential is by exposing the fact that, see, this is how the policies are being developed. Second, also by, providing a kind of a resistance to this, by representing those communities, those people whose interest and whose concerns are not getting reflected otherwise in the larger policy framework. And there is a reason why, I started with these two books and why they got published in the early 2000s. So there is a reason, there is a larger policy context, because then we have to, move a little backward to the 80s or to the 90s and to check that, okay, what has been happening in the world, particularly in the third world. In the 80s, it is famous or infamous for this large-scale privatization drive in some of the third world countries, and most importantly in South America. And that was a kind of a reflection of similar movements in the first world, particularly the United Kingdom and the United States, which some literature call it as Reaganism, Thatcherism, so on and so forth. The idea was, to promote in a way withdrawal of the state and introduction of private actors in almost all sectors, including water sector. And this privatization, including in the water sector, particularly in urban drinking water sector, that led to some serious protest. And the serious protest was because the promise of privatization and the extent to which it could deliver the promises, there was a huge mismatch. Because it came with huge promise, like, okay, because this place is going to be like, wonderful, once the private actors are allowed to operate. But apparently the reality was significantly different, and this mismatch particularly affected those who were the poor and the marginalized, and that led to serious public protest. And you might have heard about this famous public protest in Bolivia, which in literature is referred as Cochabamba Water War. And it was an anti-privatization movement. And almost at the same time, we can see similar kind of mobilizations in India, mainly, driven by tribal populations, farmers, some NGOs, rural poor, urban poor, etc. And for instance, these big anti-big dam movements like Narmada Bachao Andolan, and some references have already been made by previous speakers, and movement against water extractive industries like Pepsi and Coca-Cola, and Plachimada being one of the prominent case studies in this regard. And also, movement against urban drinking water privatization. For instance, there was a big movement in the early 2000s in Delhi, and against privatization in urban drinking water sector. So the timing, you can easily see that there is a matching as far as this timing, and it's larger policy context of what they call as the neoliberal drive, including, and one important aspect of that is privatization and, if possible, commoditization of everything, including the nature. Because there is a theory, particularly an economic theory, that believes that putting a price tag on everything is the best way to conserve it. And the larger reflection of that can be seen in environmental law, be it in the form of carbon trading, market mechanisms, etc. And the same thing, or even in the case of green economy, payment for ecosystem services, so on and so forth, there is a larger drive towards it. And this whole movement is not an isolated thing. That was the reason why I started with early 2000 and then moved backward to the 80s and 90s, and now going all the way down to 2012 when we decided that, okay, green economy idea is the best one to protect environment. So this whole is a kind of a continuum driven by a larger policy framework. So if at all, we are trying to see it as accidents and in piecemeal, I would say that we must be very, very cautious, because there is a larger picture at the background, and we must get that larger, broader picture. And this is the context where, we talk about social movements, because social movements, in my observation, it serves two important purposes. One, it provides a kind of a resistance by saying that, look, this is what is happening. And there is an interesting way in which social movements serve this purpose. It is not like us, by using sophisticated scholarly language, or by publishing, dozens of articles or book chapters, in an academic way. Social movements, most of the time, they do it by narrating the routine experience of the people, by highlighting and exposing that, okay, this is what people's life is. And obviously, that's easy for everyone to understand when we compare it to the sophisticated language and used in academic publications. Second, by using these kinds of resistance, they sometimes they move to the next level where, I mean, they also try to provide an alternative. For instance, I mean, as far as this privatization of drinking water supply is concerned, I mean, there was a larger move called remunicipalization. Remunicipalization means earlier there was this municipal water supply, and then it turned to private water supply. And then these movements, I mean, use the same vocabulary in order to coin a new term called what we now need is a remunicipalization of water supply, means taking it back to. Or there was a very interesting book even with a title called Reclaiming Public Water, which means like, okay, it has somehow turned into private. Now we have to transform it into public. So reclaiming public water. And there has been numerous case studies and examples and illustrations from across the world about these kinds of reclaiming public water movement. So this resistance and alternatives, and that is what I'm going to focus in next 10-15 minutes before I wind up. So how do they present resistance, and how do they present alternatives? One, in terms of exposing inequity and injustice, and that is precisely the reason why I took social movements as a starting point, because there is a peculiar and interesting way in which social movements expose the problems, the fault lines in the water sector. For instance, like sometimes they talk about the poor people and ask this important question that, I mean, why the elites and the privileged are able to get 24 hours or running water supply. Why some poor people, why some people in certain localities are unable to get even a small quantity of water which could satisfy their bare minimum. While some people need to just, rotate their tap, why some people, particularly women, have to walk long distance, have to wait for water tankers or walk long distance to fetch water for their basic purposes. Why there is a disparity between these conditions in urban areas and rural areas. And if we want to bring, or in fact, I believe we must bring that is an ecocentric approach, like, okay, why these kinds of policies eventually becoming a kind of a violence on the environment, like how ecology's interests are being taken care of, or while the rights of environment, how they are being taken care of. And in certain cases, by exposing all these things, social movements bring a very interesting aspect of law that is, in a way, directly or indirectly, the social movements describe that, okay, what do they expect the law to do? In a way, it is a kind of a reiteration of the expected role of law. Like, okay, what are the functions that the law needs to serve, or law is expected to serve? Because quite a number of times, or quite often, we emphasize this point in our classrooms, in law's classrooms, like, one of the functions of law is to achieve justice, and we set a lot of standards of justice. And the social movements also very smartly, they use this vocabulary and saying that if this is the expected role of law, and then it is very easy to compare and contrast with the reality of law. So what is that reality of law that some of these social movements have tried to expose? The reality of law is that sometimes it perpetrates injustice and inequity through absences. For instance, in certain cases, you may argue that, well, there is no law, or there is inadequate law. So that's about absence of law and its consequences. And then that might logically lead you to argue for more laws, more enactments. Sometimes you are also worried about excess of law because there are too many laws, and then you start worrying about implementation and enforcement. That's another part of the story altogether. So while absence of law is one problem, in certain cases, presence of law is a problem. And why presence of law is a problem? Presence of law becomes problem because sometimes law tends to serve the interest of certain class of people. For instance, this is what the Plachimada movement against Coca-Cola has been trying to expose. In one way, they said that, look, there is a reason why, Coca-Cola is able to win the legal battle. Because in that case, to a great extent, this company called Coca-Cola, they won the legal battle mainly because, or their major argument in the courtroom was the existing groundwater law supports their exploitation of groundwater. Because the existing groundwater law supported the right of a landowner to extract groundwater. And Coca-Cola's argument was technically correct to the extent that, they did not violate any law, and how then the legal system can punish them, how the legal system can deprive them. Technically, that's a sound argument. So in that case, what else you need to do? You can't ask a judge to forget about law. And in that case, what the social movements generally they do is that they expose the fact that, look, this is what the law is doing. If your law is supporting only one set of people and undermines the interest of a large set of people, and that too, the interest of the poor and the marginalized, then what is this law standing for? In other words, they advance a broader argument, more deeper argument, in fact. They talk about the politics of law, or they talk about the political economy of law, which I am sure, many of us refuse to get into that in our law classrooms. But in fact, the reality is that the law does have, or law has a political side too. So that is something that, that's what they said that they expose. If we carefully observe social movements and their narratives, we might be able to understand this reality of law, and the reality of law with sound empirical proof, because they use people's life and their pain and their sufferings in order to describe this reality of law, or the underlying politics or political economy of law. And again, I don't mean to say that it is a general theory about politics of law. It's many a times it is about the politics of a specific law, not the law. It could be a description of politics of a particular statute or a particular judgment. So we must be also very careful in terms of that methodology, whether we can generalize, we can develop that into a general theory of law. So right now, my focus is more specific in nature rather than a general theory of law. So this, okay. So this is how, I would really like to locate the social movements, and how social movements are useful for lawyers and law researchers in order to understand certain pockets and certain fault lines of inequity and injustice in the water sector. And as I said, in addition to Plachimad, I would like to use a couple of minutes to illustrate another thing, that might clarify, how this methodology can be employed in our individual work. Because in 2014, there was a very interesting order from the Mumbai High Court. And the case name was Panhak Sami. And the case, the respondent in that case, the major respondent in that case was the Greater Bombay Municipal Corporation. And this Panhak Sami was a collective, a kind of a movement for urban poor, slum dwellers. So their major argument was that some of these so-called illegal slums, unauthorized settlements, they do not receive piped water supply. And whenever they ask the corporation's reply is that the law does not allow them to do it, because these people are residing in illegal settlements. So their right over the dwellings they live is illegal, which means they do not own or they are not on rent. These are the two main ways in which any individual in this country can occupy a place. Like either you must have money to buy, or you must have a little less money, but that is good enough to take a place on rent. if you do not fall into these two categories, and if you do not happen to be a member of a wealthy family, then your life in all probability is likely to be filled with a lot of illegalities. And illegalities would lead to a number of disentitlements or disenfranchisement, because many rights would be taken away from you because of the illegal nature of your life. So Panhak Sami was trying to challenge this kind of approach. So their major argument was that there are at least a few judgments, including by the Supreme Court of India. It says that everyone in this country has a human right to water, a fundamental right to water deriving from Article 21 of the Constitution. So their question was, I mean, if it is a fundamental right, then why do you unnecessarily bother about ownership or occupation of a premises? Because if it is a fundamental right, the only question is like, are you a human being? Especially if you are talking about Article 21, you do not even need to worry about the political status, the citizenship status, because it uses the word person, not citizens. So you just need to be a person. And if you are a person, then you are entitled to that fundamental right. And then it is the state's duty to take all possible measures in order to realize those fundamental rights. If that is the case, then the argument of the corporation that, I mean, these people are, I mean, illegal occupants and therefore they cannot be supplied water is a faulty argument, not supported by the letter and the spirit of the Constitution. In nutshell, that was the argument raised by this Panhak Sami in this particular case. And by doing that, they exposed this kind of perception among the bureaucrats, among drinking water supply agencies, and probably among many of our fellow citizens, because many of our fellow citizens might also believe that, okay, these people are pavement dwellers, homeless people, illegals, and so on and so forth, and therefore they do not deserve any kind of rights. But the reality is that is a faulty argument if we have to rely on the Constitution of India, and particularly something like a fundamental right to water deriving from Article 21 of the Constitution. And yeah, I mean, the High Court of the Bombay High Court actually accepted this argument. And in fact, they wrote a line saying that, I mean, the nature of land ownership, the question whether you are a homeless person, you are a tenant, or you are an owner, these things are irrelevant. Irrelevant, at least when you talk about fundamental rights in Part 3 of the Constitution. So Bombay High Court accepted it. And of course, I mean, I don't mean to discuss too much about this particular case, mainly because, I mean, there are numerous fault lines, even in the way the court said this. But I mean, I would strongly encourage, I mean, if any of you are interested to go through that judgment, because it then, I mean, on the one hand, I mean, it says that, okay, it's part of universal human right. And in the next paragraph, I mean, they kind of self-contradict. So I mean, at least, I mean, in personal reading, I mean, I have very serious problems with the way that judgment was written. But in fact, that is not our focus point here. Our focus point here is how how social movements, how they expose some of these fault lines, and how they use law. On the one hand, they may blame law. On the other hand, they may also use law and legal forums or they may use law, I mean, for emancipatory purposes. And the interesting part is they are using it particularly for or on behalf of some of the most marginalized sections of our society. So this is how, I mean, they operate, and this is how, I mean, lawyers and law students and law researchers, I mean, may want to look at this thing. So how do we situate? This is the last point. So I would end in a minute or two. So how do we situate social movements in our larger analysis or study of water law. One way is, one way at least I found it very interesting is that from policies, from legal instruments, be it at the international level or at the domestic level, most of the time we get a particular viewpoint. We can call that as a dominant discourse. And sometimes it's possible that these viewpoints represent the viewpoints or the interest of the elites and the experts. Because policy making space is largely dominated by experts, including sometimes academicians. We believe that we know everything. And we also believe that, layperson doesn't know anything. So we live in the world of esotericism. But the point is that some of these social movements, they help us. In fact, they kind of disturb our analysis by saying that, see, yours is only one way of looking at things. There is an entirely different way of looking at things. And we can call that as a local or a subaltern discourse. And one way, if at all we are willing to understand alternate discourses, one way to understand that is to take social movements seriously. Listen to them, read them, their viewpoints. And most of the time, they do it in the light of real life experiences, not in an abstract way like you and I are tempted to do. And then the second part is that, they also, sometimes expose certain so-called progressive concepts and principles of water law. For instance, human right to water. They might tell you a different story of human right to water. For instance, like what Narmada Bachao Andolan case has told us. For instance, one of the important parts in the judgment where the Supreme Court said that this is very important for satisfying the drinking water needs of some of the water scarce areas, which is fair enough. But then the counter argument is that, then what about those people whose drinking water needs are being curtailed because of submergence? What about those people whose houses are being demolished? And what about the drinking water needs of a large number of other living beings? So there's a counter thing. This is not to say that, okay, one is right and the other is wrong. This is the important point here is, by listening only to one aspect, we might be looking at a partial picture, an incomplete story. So if we want to look at some other things, for instance, the Plachimada people, they told us a story about, how human right to water is becoming kind of meaningless because your groundwater law supports the exploitation of any quantity of groundwater by a multinational corporation. So that is a subaltern story of, on the one hand, you have human right to water, said and done and written everywhere in your black letter law. And on the other hand, people are unable to make any sense of it. So that's kind of a problem. If we go down that route. And the third point, I would like to mention here is we can also use it not just in water law, but generally when we talk about understanding law, is that whether we can thought of developing it into a larger theory where law's default affiliation is with certain class of people and certain class of interest. If that is the case, and I'm sure, I think it is very tentative and half-baked, half-cooked from my side, but this is worth considering that, whether many of these examples in front of us would help us to develop kind of a critical theory about law. I think I will stop here, and I'm sorry if I have been abstract. Yeah, thank you so much.
Thank you, Dr. Kunan. Please be assured that your lecture is very much well within the idea with which we started this webinar. And most of the papers that we have, they are sort of examining the water regime or the natural resources regime against the commodification, privatization, and also against the neoliberal agenda. So I'm sure they have a lot of reading to do. Yeah, thank you very much. Yashita?
I'm generously thankful to Dr. Kunan. I thank you, sir, for making time from your busy schedule to provide your esteemed inputs for today's national webinar. Your generalization of the topic gave us wide perspective to the issue we are facing with regards to the injustice and equity of water. Thank you so much, sir.
I think I'm allowed to leave, I guess, right?
Yes, Dr. Kunan, please.
Yeah. Thank you.
Thanks again.
Thank you. I'm also leaving. Okay.
Oh, thank you, sir. Thank you very much for such an interesting lecture.
Great. Nice hearing very learned lectures.
Sure, sir.
Ma'am, we'll take a short break now, ma'am, and we'll assemble again at 2:30 for the technical sessions. So all the participants, all the paper presenters and the chairpersons are requested to join through the same link and remain in this session.
At
and like
2:30.
Yeah, 2:30 we'll start the technical session. We have two technical sessions today, technical session 3 and technical session 4. And we also have student session 2. So all the participants, all the paper presenters and all the chairpersons are requested to join through the same link and remain with the session. We will take you to your respective technical session and student session. Thank you so much.
Thank you.
Sir, good afternoon, sir. Sir, in 5 minutes,
Good afternoon.
in 5 minutes we are starting, sir.
Okay.
We are just creating the breakout room, sir.
Right.
We'll be starting in 5 minutes, sir. We will take you to your respective technical session, sir.
Fine. Thank you.
You'll get a notification. You'll get a pop-up on your screen, sir. You just have to press OK, and we'll take you to your respective technical sessions.
Right.
Yes,
Thank you.
yes.
Professor Ramesh sir, namaskar.
ನಮಸ್ಕಾರ ಚಿದಾನಂದ್. ಅರ್ಧ ಗಂಟೆ ಕೇಳಿದೆ ಎಲ್ಲಾನು ಪ್ರೆಸೆಂಟೇಷನ್ಗಳನ್ನ. ಒಬ್ರು ಕನ್ನಡದಲ್ಲಿ ಬೇರೆ ಬಹಳ ಚೆನ್ನಾಗಿ ಮಾತಾಡೋದು.
ಅಖಿಲ.
ನಮಸ್ಕಾರ ಪ್ರೊಫೆಸರ್ ಭಟ್ರಿಗೆ.
ನಮಸ್ಕಾರ. ಥ್ಯಾಂಕ್ ಯು.
ಇಟ್ಸ್ ಬೀನ್ ಮೈ ಪ್ಲೆಜರ್.
ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದ್ರು.
ಹೌದೌದು.
Nicely, whether other sessions are going on? Nicely. Nicely has muted, it seems.
No, Akila informed that I think there's some student presentation still going on.
Yeah, that should be the student free.
Really, hudugar participation bada mukhya. They are the future hope for us.
Good afternoon, sir. That student session is still going on, sir.
VC sir, ಸ್ಟೂಡೆಂಟ್ ಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಇನ್ನು 2 ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಇದ್ದಾರೆ ಪ್ರೆಸೆಂಟ್ ಮಾಡೋದಕ್ಕೆ. It may take another 10-12 minutes. That session is going on. ಇದು ವಿನೂತ್ ಅವ್ರದ್ದು ಪವರ್ ಪಾಯಿಂಟ್ ಚೆನ್ನಾಗಿತ್ತು, ಓನ್ಲಿ ಪಿಕ್ಚರ್ಸ್, ನೋ ವರ್ಡ್ಸ್.
ಅಲ್ಲ, ಇದು ಏನೋ ಬಹಳ ಸ್ವೀಪಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಇದು ಲಿಂಕಿಂಗ್ ಆಫ್ ರಿವರ್ಸ್,
ಅದು ದಟ್ ವಾಸ್ ವೆರಿ ಅಗ್ರೆಸಿವ್, ಅನ್ಸೈಂಟಿಫಿಕ್.
ಅನ್ಸೈಂಟಿಫಿಕ್ ಅಂದ್ರೆ ಸಾರಾಸಗಟಾಗಿ ಹೇಳಿದ್ರೆ ಈಗ
ಇಲ್ಲ, ಹಂಗಾಗೋದಿಲ್ಲ. You have to study. There are pros and cons.
I think some of the observations are taken from some report or the other, or some comments that are made, maybe even newspapers. So those opinionated things will perhaps register with them.
Morning complete utilization of water dimension in Mohan Kathaki's address was good.
He is a very learned fellow.
ಅದೇ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಪ್ರಿನ್ಸಿಪಲ್ಸ್.
ಎಸ್ ಸರ್.
ರಿಸಾಲ್ವಿಂಗ್ ಅದು ಡೊಮೆಸ್ಟಿಕ್ ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್, ಅದನ್ನು ಚೆನ್ನಾಗಿ ಹೇಳಿದ್ರು.
ಚೆನ್ನಾಗಿ ಬಂತು ಸರ್.
ಹೌದು.
Irrespective of who is upper riparian, who is lower riparian.
Water generates so much of heat.
Water it does evaporate in that heat.
Most of the time you find it very difficult to distinguish what is politics and what is law and what is policy.
Yes, sir. Really, because all the tangent forces are fighting for water, water is confused.
I think the real issue just gets under the carpet.
Yes, sir.
They are not bothered. Knee-jerk reaction and immediate solution for their immediate needs. ಮುಂದಿನ ಯಾರು ಯೋಚನೆ ಮಾಡಂಗಿಲ್ಲ.
It is a very
Tell me
serious
the story
issue.
all the while.
Very serious issue to be considered. And
as a right issue
people
or
should be speaking.
conflict resolution, I think we only talk of principles, but when it comes to action and actioning,
yes, sir.
Everything is thrown to winds.
Sir, inaugural alli honorable minister matadidru sir. He has a very, very comprehensive idea about managing water. Bala ಚೆನ್ನಾಗಿ ಮಾತಾಡಿದ್ರು sir. We are not addressing the flood issue properly ಅಂತಂದು ಹೇಳ್ತಾರೆ ಅವರು. ನೀವು ಫ್ಲಡ್ ಇಶ್ಯೂ ಅಡ್ರೆಸ್ ಮಾಡದೆ ಈ ವಾಟರ್ ಶೆಡ್ ಟ್ಯಾಂಕ್ಸ್ ಪಾಂಡ್ಸ್ ಮಾಡಿದ್ರೆ ಕೊಚ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತವೆ ಎಲ್ಲ. ಫ್ಲಡ್ ಬಹಳ ಚೆನ್ನಾಗಿ ಮಾತಾಡ್ರಿ ಸರ್. ಎಕ್ಸಲೆಂಟ್ ಅಡ್ರೆಸ್. ಅದು ರೆಕಾರ್ಡ್ ಇದ್ರೆ ಕಳಿಸ್ಕೊಡ್ತೀವಿ ಸರ್. ಅದು ಯು ವಿಲ್ ರಿಯಲಿ ಅಪ್ರಿಷಿಯೇಟ್ ದಟ್.
Good evening, sir. Sir, student session got over, sir, just now.
Okay, then ask all of them to leave that room or close that room so that they will compulsorily come here.
Yes, sir. Sir, everyone are joining to the main session, sir.
Okay, good.
Yes, sir.
Allocation.
You need to end all the breakout rooms. There is again a request to join breakout room.
Yes, ma'am.
Good afternoon.
Good afternoon, sir.
Good afternoon, sir. Good afternoon. Good afternoon, sir. Ramesh, sir.
Afternoon. Namaskar.
Good afternoon. Good afternoon.
Tamma Ganapati.
Ganesh.
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 I only know him as Ganesh.
Yes, sir.
TB
Yes,
Patil ಅಂದ್ರೆ ಯಾರೋ ಹೊಸಬ್ರನ್ನ ಹೆಸರು ಕೇಳಿದಾಗ ಆಗುತ್ತೆ.
Correct, sir. Correct.
Rashmi, you may begin, please.
Yeah, ma'am. Ma'am, the participants have already joined the main session, ma'am. We can start.
So very good afternoon, everyone. This is Rashmi P. Mandi, student, KSLU's Law School, and it gives me immense pleasure to extend a warm and a cordial welcome to the dignitaries, distinguished invitees, and the participants to the valedictory session of the two-day national webinar on emerging trends in water resource management and law, with special reference to Karnataka, which is organized by the Center for Research in Water Resource Management and Law, Karnataka State Law University, in collaboration with Ministry of Minor Irrigation, Government of Karnataka. May I request Professor Dr. G.B. Patil, Registrar KSLU, to kindly welcome the dignitaries and participants. Please, sir.
Good afternoon to all. Esteemed dignitaries on this platform, ladies and gentlemen. It gives me immense pleasure and satisfaction to welcome the dignitaries on this occasion. We are in the valedictory function of a two-day national webinar on emerging trends in water resource management and law, with special reference to the Karnataka. Right? Today we have Professor M.K. Ramesh, a great teacher, a great academician, and a multifaceted personality who is always associating with KSLU. Whenever an invitation is extended to sir, he is wholeheartedly participating in all our activities. Sir, we are very happy and overwhelmed.
Thank you.
It takes me to again, in 1990, when I got an appointment in KLE, you took me to Hotel Dharwad and offered me dosa and jamun. That was my memory in 1990. You have blessed me then, and the blessing continues even now also. Sir, we are very much overwhelmed by your gracious presence. On behalf of all the statutory officers of Karnataka State Law University, I extend a cordial welcome to you, sir. Welcome you, sir. It is also my pleasure to welcome Professor P. Ishwar Bhatt, the Vice Chancellor of Karnataka State Law University, an eminent teacher, a renowned research scholar, sharing always new thoughts and new ideas, prompting youngsters to think in a different way. Sir, under your leadership, the university is marching ahead. On behalf of all the statutory officers and all the staff and students, I extend a welcome to you, sir. It is also my pleasure to welcome Professor C.S. Patil, Professor, Senior Professor of Karnataka State Law University. Sir, we are happy and it is my pleasure to welcome you to this particular valedictory session. It is also my pleasure to welcome Muhammad Jubairian, the registrar, who is always a guiding force to organize such academic activities. I extend a warm welcome to him also. It is my pleasure to welcome Ratna Baramgowda, Dean and Director of Karnataka State University's Law School, for this valedictory function. It is also my pleasure to welcome all the esteemed participants, the resource persons, all the delegates, paper presenters, and all the distinguished invitees for this particular valedictory program. I thank everyone for this opportunity. Thank you.
Thank you so much, sir. I would also extend a warm and cordial welcome to you for the webinar.
Thank you.
May I request Dr. Akhila Baslalli, Senior Research Assistant, Center for Research in Water Resource Management and Law, Karnataka State Law University, to present the report of the webinar. Please, ma'am.
Thank you, Rashmi. It gives me immense pleasure to present before you the summary report of two-day national webinar on emerging trends in water resource management and law with special reference to Karnataka, organized on 17th and 18th of January 2022 by the Center for Research in Water Resource Management and Law, KSLU Hubli, in collaboration with Ministry of Minor Irrigation, Government of Karnataka. The program on 17th began with the welcome address by Professor Dr. Ratna Baramgowda ma'am, followed by the opening remarks by Professor P. Ishwar Bhatt, the Vice Chancellor and the head of Water Law Center, where he pointed out the importance of integrated approaches towards water, the integration of Jal, Jungle, Jameen in the conservation of water resources. The webinar was inaugurated by Justice Shri K.L. Manjunath, who in the inaugural address took us through the problems Karnataka is being facing, starting from the kind of effluents or the medical waste, the great hospitals are releasing to the water without treating, to the sufferings of the endosulfan victims. And he also urged the government to be taking immediate measures to address the same. This was followed by the keynote address by Dr. Avdesh Pratap, who pointed out some of the general principles and international principles that govern water courses law today. He presented his paper on interlinking of rivers between the states and water scenario. He also spoke about what is better for the water governance and the river health. This was followed by the presidential address of Shri J.C. Madhuswamy sir, the Pro-Chancellor and the Law Minister of Karnataka, and also the Minor Irrigation Minister, where sir promised the better management of water resources, and he also highlighted the model of China that basically uses the flood water to irrigate those lands which are drought poor. And he also mentions the importance of the research institutions, especially the Water Research Institute of Karnataka State Law University, how it has to collaborate with the ministry in providing the policy suggestions and also implementations of schemes. The inaugural function ended with the vote of thanks by Professor Dr. C.S. Patil. The plenary sessions began immediately, and the first plenary session we had two speakers, Dr. Rajendra Podar, Director, Valmi Institute, Dharwad. Sir presented his lecture on the paper Community-Based Water Management as a Solution for Water Crisis. This was followed by the lecture delivered by Professor Dr. Sairam Bhatt, Professor of Law, National Law School, Bangalore. And his lecture was titled Agricultural Water Resource Policy Challenges for the Center-State Relations. Then the second plenary session began with Ms. Rupa Hasan from Hasiru Bhumi Pratishtana talking about the importance of rejuvenating the tanks and kalyanis. Her paper was titled Paramparika Jalamulagala Rakshane Yake Mattu Hege. This lecture was further followed by a talk by Dr. Prakash Kulkarni, the president of Bhagirath Institution, where he spoke about the pollution of water bodies, legal and technical aspects. So after the second plenary session, there were two technical sessions where the paper presenters presented their papers, and there was a student session where we had the students also present their papers, which was chaired by our Honorable Vice Chancellor. The kind of comments that Sir gave, we are hoping that those papers will be coming up for publications. The second day, we started with the third plenary session. The first session, that is today's session, the first session was from Professor Dr. V.G. Hegde, Professor of International Law and the Chairperson for Center for International Legal Studies, JNU. He took us through the evolution of international legal principles on sharing of international water courses. And this lecture was followed by another very interesting talk by Shri Mohan Kataki, who is a senior advocate of Supreme Court of India, where he discussed the influence of international law on interstate water disputes. The fourth plenary session began immediately with the lecture on Cauvery water dispute and international water law principles by Professor Dr. Tony George, Professor of Law, O.P. Jindal, Global Law School, where he took us through the historical background of how the Cauvery dispute even emerged. This was followed by a very intriguing lecture by Professor Dr. P. Ishwar Bhatt, the Vice Chancellor and the head of Water Law Institute, where he presented on the elements of equity, ecology, and developments within the Mahadai report. The way Mahadai report is more or less a green decision is what he presented before us. The last lecture of the fourth plenary session was by Dr. Sujit Kunan, Assistant Professor of Delhi University, Faculty of Law. He emphasized on the social movements, how social movements play a very important role in challenging the water inequity and injustice. So after the fourth plenary session, again, there were two technical sessions where there were paper presentations, along with the student session too, which was chaired by Professor Tony George, again, sort of giving the comments the day two, and we are in this valedictory session, which is presided by Professor P. Ishwar Bhatt, our Vice Chancellor, and we are also fortunate that Professor Dr. M.K. Ramesh has agreed to deliver his valedictory address. I also acknowledge in this report that we are in the presence of we're in the esteemed presence of Professor C.S. Patil, Professor Ratna Baramagowda ma'am, Registrar Sir Mohammad Zubair, and several other dignitaries. Thank you very much for giving me this opportunity to present the summary report.
Thank you so much, ma'am. May I request Ms. Maheshri, Junior Research Assistant, Center for Research in Water Resource Management and Law, Karnataka State Law University, to kindly introduce Professor Dr. M.K. Ramesh. Please, ma'am.
Good afternoon, all. It is a great honor for me to introduce today's chief guest, Professor Dr. M.K. Ramesh. Professor Dr. M.K. Ramesh obtained Bachelor of Science, Masters of Law, Doctor of Philosophy in Law from University of Mysore. Professor Dr. M.K. Ramesh has been a professor at the National Law School of India University since June 1992 and superannuated on 13 November 2021. Sir also served as the University Vice Chancellor between August 1st, 2019 and September 25th, 2019. He has teaching experience of over 40 years and has worked for over 2 years as a commercial tax officer in the government of Karnataka. His areas of specialization include international law, human rights law, environmental law, and natural resource management law. Sir did 3 centers of excellence at NLSIU, Center for Environmental Law Education, Research and Advocacy in 1997, Common Cell 2009, and Environmental Law Clinic 2012. He was a senior Fulbright Fellow in the US 2005 to 6 and an Environmental Law Fellow 2006 at Environmental Law Institute, Washington, D.C. He's the founder editor of Indian Journal of Environmental Law and has published about 60 research articles and 5 books. Professor Dr. M.K. Ramesh's teaching experience includes adjunct professor at IIT Kharagpur between 2010 to 2014, visiting professor at KTH Stockholm, Law School Zurich, Dalhousie Law School Canada, and visiting professor at Law School Warwick, UK 1996. Professor Dr. M.K. Ramesh has been associated with teaching the course on environmental justice at Pace Law School at New York, US 2005 to 6. Professor Dr. M.K. Ramesh has held the positions as chairperson, chair professor, Urban Poor and Law instituted by the Ministry of Housing and Urban Poverty Alleviation, Government of India 2011 to 2016. Chairman, Research and Policy Advocacy Committee and member, Research and Policy Advisory Committee at Ministry of Environment and Forest and Climate Change between 2010 to 2016. He's been a law expert member at National Biodiversity Authority, member steering committee for 12 5-year plan on environment, forest, wildlife, and climate change planning commission, member expert group reviewing the draft guidelines for the development of national legislation on liability, response action, and compensation for damage caused by activities dangerous to environment, prepared for the consideration of the Governing Council of the United Nations Environmental Programme in Geneva in September 2009. Institutional representative member for India in the International Environmental Law Army at Canada, member Human Ethics Committee and member STEM Research Ethics Committee at IISc, expert law advisor, Legislative House Committee on Lake Encroachments, Government of Karnataka in 2016-17, law expert member, task group on evolving comprehensive water policy for Karnataka, member law expert committee advising MP's Biodiversity Board, member expert committee for reforming biodiversity law, environmental law fellow 2006, Environment Law Institute at Washington, D.C., and delivered lectures into law at Sri Lanka and Nepal, Kathmandu. Sir has also been on the board of directors, Center for Sustainable Development, Bengaluru, since 2014, and is also a life member at ISET. He's visited US under the International Visitors Program and the UK under the Faculty Exchange Program in 1996. Professor Dr. M.K. Ramesh's research activity include as a member of a number of expert bodies concerning environmental law and governance. He has been involved in aiding, advising, and assisting the state and central government and contributed to the environmental lawmaking by engaging in a number of legislative drafting exercises that include water management, biodiversity. He advised the Government of India and assisted in its preparation for the Paris Agreement on climate change in 2014-15. His contributions have been utilized by UNDP, UNEP, ADB, World Bank, IUCN, voluntary groups, and a few academic and research institutions, both in India and abroad, in carrying out research activities and training programs concerning environmental law, waste management, biodiversity law, human rights law, public service lawyering, and legal education. Sir has developed a manual on hazardous-based management law in India for Environmental Law Institute, Washington, D.C. We are humbled to have you with us today.
Thank you so much, ma'am. It's a privilege to have Professor Dr. M.K. Ramesh former professor of law, National Law School of India, University, Bengaluru. May I request sir to kindly deliver the valedictory address, please, sir.
Thank you. Esteemed Vice Chancellor of KSLU, Professor Ishwar Bhatt, my colleagues and young friends, Professor Chidanand, Professor Ratna, Professor Ganesh, the registrar of the law school, the members of the faculty, the research group, the entire group of organizers, the participants of the event. Ms. Akhila's presentation of a report, I think, introduces every one of us to a veritable reservoir of a gold mine of information, research and analysis on a subject which has developed more heat than light, all the while ever since we became independent, and a subject taken up for consideration in the esteemed law university. It is not just timely, but it is very necessary. I deem it a privilege to be part of the valedictory deliberations in this two-day event. If I can very quickly have a look at the presentations made, they could be grouped under about 5 or 6 heads. It starts with the identity of water, whether it has its own personality or its personality gets submerged in so many other personalities, and as to even give us the impression whether it has any identity at all in law. The second set of presentations, of course, focused on management, the state-centric, the center-state relations, participatory management, the communitarian engagement, the private and joint sector initiatives, decentralized governance, and traditional systems of water management. The third aspect, if I go by both the presentations and also from the report that has been made available, pays attention to the ecological aspects as part of an ecosystem, as part of an ecosystem service, stress on the imperative of conservation and the issue of recharge, the groundwater especially, rejuvenation, restoration and reclaim of lakes and water bodies, drinking water, and issues in relation to that. And in terms of application, the next aspect, besides drinking water and the domestic use, the focus on agriculture, industrial use and the pollution issues as a tool of development and in the urban context. Whole lot of discourses on that around application part. And on conflict resolution, you had a very detailed inquiry and you had international experts on that subject. Besides that, you have a group of presentations which viewed everything through the lens of human rights, human entitlements and human needs. And there were a few case studies available, including the last one of the presentations in which I was present. The Kali River, not the Kali of Karnataka, but the tributary of Ganga. All these, in all the presentations, were laced with a few reflections on underlying principles of governance. The focus is on Karnataka. And why focus on Karnataka? For the obvious reason that from the reports that are available and what the experts have communicated to us time and again and caution, water accessibility, availability and reserve in Karnataka is placed in the critical category, next only to Rajasthan. And one of the experts I know very intimately, Dr. Prakash, the founder of the Disaster Management Authority of Karnataka, further cautions that Karnataka is soon to overtake Rajasthan in this dubious distinction of being worst hit in water crisis. And so If not Karnataka, where else could there be a focus? And here's an academic institution which is involved in it, in the reflections on that, and why law academia should be concerned and reflect on water issues, management, law, and governance. Once again, there's an obvious reason. The obvious reason is that all those who have attempted and who have been in the actioning field, wittingly or unwittingly, have contributed to the mess and have not been successful in finding solutions, or rather have been successful in becoming part of the problem. And you're looking up to law academic institutions, whether they can offer solutions. Well, are the law academia ready, willing, interested, and equipped in contributing to finding solutions? If you actually look to the curriculum that's being brought into application ever since we started our law degree programs all over India, right from the time when we were independent, when we became independent. Sadly, water law discourse has been hardly been present, let alone being significantly be present. Even to this day, they're not yet equipped. There is hardly any discourse, no single dedicated course on water law as a compulsory course for students of law in any law teaching institution anywhere in India. With a little over 20 years of my experience in research and teaching on water related issues concerning law, in my 40 odd years of experience, this is the home truth that I have learned. Law teaching institutions and law professionals who come out of that hardly have the knowledge and the skill in dealing with the varied issues concerning water, with few honorable exceptions. I hope this seminal effort on the part of KSLU would be a path-breaking one and would show us the way as to how to go about the imbroglio that we have gotten into. Emerging trends in water resource management and law, with special reference to Karnataka. In this address of mine, I just would like to deal with that under 4 or 5 heads. I will start with the law and management discourse of water, which is more or less something that has reverberated in all the presentations by each one of you in some form or other. I'm trying to encapsulate that. And if I can just put it in one single sentence, law and the management, the entire discourse of that is full of contentions, conflicts, and confusion. Water, as a person, suffers from an identity crisis. Is water endowed with an identity of its own, distinctively different from any other resource? The jurisprudence that has been developed, the Anglo-Saxon, the Anglo-American, or any other, is of not much of a help in this regard. In terms of conceptualization of water, how do you conceptualize it? We have difficulties. Are you going to refer to it as something which is the life support, the elixir of life? Or would you view it only as a commodity, a consumable goods? And here you have a bit of a difficulty. Is it a consumable goods? The interesting thing about water is consumable, of course, but after that, there is some other water that's available still. And is it the same commodity that you're referring to? Well, you get a bit of a difficulty on that. Is water a common property? Well, there are views which are just like the different hues and colors of a rainbow. Do any of these perceptions encapsulate its ecological, social, cultural, religious, and economic significance of water. They do give some shades of it, but not a holistic picture. Interest, rights, entitlements, and ownership claims. These take the pride of place in the entire legal inquiry and the management strategies. But what about the basic need for water? This unfortunately remains in the margins and is a footnote. There is a very interesting paper in this wonderful volume by Ramaswamy Iyer, edited work, Water and the Laws in India, in which Professor Upendra Bakshi offers a suggestion to the constitutional vocabulary that just before the fundamental rights part, we needed to introduce one more, something which is non-negotiable and something which is very basic as a need right. Something that should be basic and something which anyone in the governance system should really higgle and haggle and bargain, and this should be assured to everyone by the state before addressing the right issue. In addition to all this, you have the question of dealing with the right of the ecosystem, water as an ecosystem. Does it have a right of its own? Well, the Waingani judgment in New Zealand may be a pathfinder, and maybe something that came in the Uttarakhand High Court's judgment may shed some light, but not much has really developed by way of a jurisprudence in this particular area of law. Issue of ownership and control. Other than the water that lies within the confines of private property, which is fairly more or less settled, the right over which rests entirely with the owner of the land under common law tradition. But what about those that is there in the public domain? State property, community asset, something that could be bargained by the private enterprise? Well, there are theories and theories in relation to that. We will shift to law and governance. In the introductory chapter to one of the major benchmark work on water law, way back in 1992, reflecting on water law and governance, this is published by the Indian Law Institute. I think that was perhaps the first major legal jurisprudential work on water in India. Professor Upendra Bakshi comes up with a catalogue of issues which have afflicted water governance in India. To borrow the famous words of one of the Nobel laureates, India, an organized chaos, very aptly is applicable to water law and governance. Integrity of water, a natural attribute, hardly gets respected or observed either in lawmaking or its management. Certain aspects of these do really make a mention, do really find inquiry and get addressed, but not in toto, not in a holistic sense of the term. Lawmaking has had little to learn from the nature of water. At its deepest level, it has stagnated, neither flown nor evaporated. Not my words. This is a quote from Chhatrapati Singh. We are still under the shackles of the old Roman law notions of property that still rules the roost with regard to every natural resource, and water is no exception. The discourse on water law is bound by that. Water as a subject is appropriated and made a subset of a larger inquiry into a wide variety of subjects and diverse concerns in law. It finds place in land law, forest law, wildlife law, pollution control law, human rights law, development related laws, agricultural law as part of irrigation, human rights law, criminal law, gender justice. The list is endless. No single policy or law that can comprehensively cover the different dimensions of water in nature or use yet to find its place in India. Governance is indeed a mirror image of the laws, unintegrated, unorganized, and operating always in silos. Just look at it. The ministry concerning water in any other state in India. Karnataka is one example. You have not less than some 25 departments, and each one of them would operate in silos. But water in nature does not exist that way. And when it comes to water management, there is iniquitous distribution, irrational allocation, and it is mired in technicalities and priorities. And in the whole process, conservation, a casualty. And the entire system is hardly proactive. Thirdly, when you get into water conflicts, in terms of conflict avoidance, conflict resolution, ensuring water integrity and security, balancing demands of development while addressing the concerns of conservation, well, these are not the virtues of the justice delivery system that we have. Right from the stage of lawmaking to its enforcement and justice delivery on that. I think you must have had very rich presentations on that. And just read the newspaper of today. This is what the Chief Minister of Karnataka has said, that the law concerning water conflict requires a thorough revision. It is drowned in the noise and deluge of political power play over interstate, center state, and human rights concerns, technical and technological aspects of irrigation and development issues. The hierarchy of courts in India have never ever been engaged in the development of a holistic jurisprudence on water in a comprehensive way. I may appear to be coming up with a very hard-hitting statement, but if you just look at the grammar that is developed, not just through the judicial pronouncements, but through the very conceptualization of water, its working, and lawmaking and its system of governance, and the facilities and mechanisms we evolved concerning conflict resolution, I don't think you can have a conclusion different from this. Tribunals, if at all anything, have contributed voluminously to the chaos and confusion, and have played a major role in exacerbating the problem. I'm not pointing fingers at any institution, but it is a system that has been reduced to that kind of a unfortunate situation. And this is something I draw from a 1975 publication, once again from the Indian Law Institute. The Journal of Indian Law Institute has devoted one full issue on water conflicts way back in 1975-76. It was dedicated to issues concerning water conflicts, and it draws the conclusion, this is the conclusion that was drawn then, that there were less conflicts before tribunals took charge, and conflicts were easily resolved where tribunals were not involved. It may appear like Ripley's believe it or not to you, but that was a fact. Of course, there is a political dimension to that, that you had before 1975 or around that time. We had primarily one single party ruling both the center and the state, most of them. And so if at all there was conflict between the state, the center would act as an umpire and then get it resolved either way. Perhaps the political dimension did really take care of that. How equitously it did it is a different issue, but it resolved and did not really add more to the problems that were already being faced. But that doesn't really mean that the entire onus is on the political leadership. But in terms of perception, the conception, and its working, we are handicapped. And water conflict resolution system have provided enough fuel, fodder, and substance to the existing controversies. This is undeniable. Let's just look into the current scenario of water resource law and management. What do you see, not just in Karnataka? Of course, I can give some examples of Karnataka as well. But all over India, the greater focus and thrust is on aligning the policy and governance concerning water with the imperatives of a liberalized economy, accommodation of and showing greater faith in private ventures in management. You had this Mysore Jaiko experiment. Although we already have the failed experiment in Bolivian model on this very same issue. Or if you look at the regulatory mechanisms that were evolved, right from 2004 and 5, we have an independent regulator that is being promoted. And there was this Maharashtra model and an experiment, partly successful and not entirely satisfactory. Then an effort in giving exclusive control and management of part of public resource to a private entity. It was such a fiasco. And what was that? You have heard of a river called as Shivana or Shivana in Madhya Pradesh. Part of it was given to an industry to manage. And that led to so much of a controversy. Or, by and large, what we have is the management system concerning water of every conceivable kind of description is more of a donor-driven venture. To turn to Karnataka, law and tank and local water bodies management in Karnataka is essentially finding its root in this particular venture. And once the funds get exhausted, the system of governance switches back to reposing renewed faith in the old system. In the middle of very first decade of this century, we came up with a requirement of a law, exclusive law on tanks and water bodies. And we came up with that law in the middle of this last decade, wherein we handed it over to certain independent authorities, primarily drawn from the forest department. And then when once the funds started getting exhausted, we quickly moved it back to the minor irrigation department, the old faithful. What had happened to the commitment that was made, giving the local property resource, the water, back to the people, which was the clarion call and the slogan, even in the budget speech way back in 2004 and 5, getting completely reversed and getting back to the usual system of governance that we had adopted right through the irrigation laws. It's not that efforts were not made in coming up with a holistic picture, but these efforts have been abortive and failed attempts in water policy and law reforms, national water policy. There was a framework law experiment. The 12th plan document came up with one such experiment. The Water Resources Ministry came up with another model, but neither of them saw the light of the day. And then it was Karnataka, which was the first state which initiated this process. I'm saying with a lot of confidence and authority for the simple reason that people came to us in the law school to really help them in developing this law. But when once we were ready, willing, interested, and even came up with a template of that, people lost interest in it. Maybe a change of government, or maybe the change of policy, change of perception, or whatever. And later, Rajasthan did come up with such a request, and a draft law was prepared for circulation, comment, review, and return. But the government was in such a hurry that it just picked a few of those ideas, came up with a law, which actually got the endorsement of the entire legislature. That was just before the elections. After the election, the entire thing was forgotten, even in Rajasthan. Back to Karnataka again. There was this committee headed by Mihir Shah, of which I was a member. In fact, I was one of the members of this particular committee, and I also chaired the task group on law issues to come up with a recommendation for a comprehensive water policy in 2000, 2018 and 17. Around that time, we got into a very elaborate exercise. But unfortunately, once again, the political equations perhaps did not really find anything to really make use of whatever that has been presented, and it is still in hibernation. These are the efforts in making policy and law comprehensive and holistic to look at all dimensions of water. And so what exists is something which is less than satisfactory. I'm an academic, a hopelessly optimistic academic at that. And so what's the way forward in this regard? I submit to you that there is no need to invent the wheel. No need for initiation of a fresh and comprehensive study. Plenty of material is available. There is sufficient number of studies and reports exist already on each and every aspect of this. It's almost like an elephant in the room situation. Don't we know the weaknesses in each of the new experiments that we embarked upon? That Karnataka ranks among the third worst affected among the states hit by the water scarcity. Don't we know the problems that has resulted in this ill-conceived policies and formulations and working? The only thing that we need to do is to restore the natural personality of water. Work with the natural rhythm of water. It's not impossible, and it's doable. You want examples? There is integrated water, law, policy, and management as something which is part of the natural resource management umbrella in countries like New Zealand and some of the Scandinavian countries. We can draw lessons from that. Or adopt the principles of integrated water resource management, the European framework law. There has been reference to that in all our policy documents. But how does that really get internalized or translated into practice is still almost like a mirage, chasing a chimera. Third, integrate the working of different agencies of state and parastatals in management of resources. We are more interested in creating new departments, new authorities, new autonomous bodies, but each of these have some implications or rather for water management. We need to really integrate them, bring in the much needed coordination and harmony in the working of different administrative entities horizontally and vertically. It should be a non-negotiable must. Administration will not like this. They want to have more authority. They want to have more positions being created for them. And this has been a bane of resource governance in India in general, water resource management in particular. You have to deal sternly with encroachments. And water bodies are the worst victims of encroachment. There are reports available right here in Karnataka. In fact, I was part of an expert committee which advised the high level, the House Committee of the legislature in Karnataka on the restoration, reclaim and recovery of water bodies in Karnataka. That report is something which has revealed so much. And that was actually presented before the legislature. No action taken. Look for less expensive, least wasteful, more homebred solutions than adapting and implementing mega expensive projects and donor-driven ventures. It's not that I am against filling wastewater into water tanks, not against project of supplying water to water-parched areas in Kolar and other districts, many such projects. But the question is, have we looked into the homespun wisdom of less expensive solutions? Have you worked on that? Have you worked on recharge and rejuvenation of water bodies and tanks by adopting simple scientific principles and solutions? You need examples? Yes, right here in Karnataka we have. The Foundation for Ecological Security has done yeoman service in the Kolar district. Please use it as a template. Or the Ravi Shankar Foundation, they have come up with several water initiatives and draw lessons from them. The next and another very doable thing is to recognize, respect, and rekindle interest in adapting the time-tested, time-honored traditional practices endowed with a native indigenous wisdom and mainstream them in the system of governance. We only talk about that, but hardly we do really translate that into action. You may just have a look at the two wonderful volumes published by the Center for Science and Environment on dying wisdom, local, native wisdom, which has been able to do wonders with regard to water bodies and water resource management. A leaf from that can be taken as making an integral aspect of water governance in the state. We will not reach the critical stage that we have already reached, and we are at the danger mark. Finally, restore faith in the local self-government institutions as the public trustees of community assets. This is the constitutional command. Public trustees of community assets. Look to the 11th schedule and mainstream their role in conceiving, planning, and executing water-related activities. Just 2 days from now, I'm going to address about 85 such local bodies just to bring to their attention what the Constitution conveys and what are those aspirations are with regard to the management of community assets, primarily water and local resources by the local self-government institutions. The dream of Atmanirbhar Bharat getting realized would not take long. Let it begin with water. The rest of the resource management will definitely fall in place. I thank you for this wonderful opportunity provided to me to share a few thoughts of mine which are not exclusively mine. I don't have any intellectual property over there. Each of these ideas that I've expressed must have reverberated in some form or the other in each and every session of what you organized here. Pick them out, put them together as a set of recommendations that can go to the government, and hopefully someday someone up above would be able to really act on it. All the best to you. Thank you.
Thank you so much, sir. May I request Professor Dr. P. Ishwar Bhatt, Honorable Vice Chancellor, KSLU, to kindly deliver the presidential remarks. Please, sir.
Esteemed Professor M.K. Ramesh, Professor C.S. Patil, Professor G.B. Patil, Professor Ratnaparam Gowda, all the faculty members, students and participants. Valedictory session is the final stage where we assess the work that we have done during the last 2 days. Various scholars have made presentations for this national webinar. We had put a lot of efforts by contacting various scholars, by writing, by persuading students, by requesting various scholars to preside over various technical sessions. And our efforts were quite fruitful in the sense that we could get very eminent scholars in the field of water law and make a very good assessment of the health of water law, health of river, health of a water body, and the health of ecosystem is one of the important concern with which environmental scholars will be proceeding ahead. Professor M.K. Ramesh, in his valedictory address, has given lot of thoughtful ideas about the concept of river, concept of water, whether a river has any personality or a water body has a legal personality. What does it mean to say that a river has a legal personality? In fact, the theories relating to legal person, which are catalogued by scholars like R.W.M. Dias and other scholars, point out a different method of dealing with the issue of recognizing a legal personality. How exactly a legal person emerges? It may emerge on the basis of conferment, concession, or fiction, or bracketing of interests, or purpose, or various other factors. About the issue of a legal person, there has been much discussion, whether it's a deity or artificial legal person. There has been much case law. About a river as a legal person, there has been some discourse. What I intend to emphasize is that the community living in a river basin identifies itself with the social, cultural, and aesthetic aspects of that river. It has that kind of a commitment, and that ecological factor has its own impact upon the link between the community and the concerned entity, legal entity. When Niyamagiri Hill is worshipped, or when Cauvery is worshipped, or the origin of Madai is worshipped, or origin of Ganga is worshipped. Actually, there is that kind of religious, cultural, and say emotional commitment to keep the water source pure and pristine. See, with reference to water, what is required is an integrated approach that has been emphasized by various scholars. I had the opportunity of listening to the presentations made by very eminent persons during the last 2 days. I am really benefited by all such presentations. One major theme that is emphasized is that we have to look into water from a holistic perspective. There should be an integrated approach. A fragmented approach is not at all suitable, because water has several sources. Water has several functions to perform, and water has a lot of things to give to the community. And the problems that are relating to water are several. The persons who are involved in management of water are several people, or several organizations, or several organs of a government or several levels of government. Unless there is an integrated approach to deal with all types of things, we are not able to solve the problems relating to water. It is a very unfortunate that we are just next to Rajasthan insofar as a critical position relating to water is concerned. That is a really unfortunate position. Karnataka is historically known for the land of tanks, land of tanks. Professor Dikshit in his book on the tradition of tanks in Karnataka explains the number of tanks, the way in which they were managed, kept, and used with all such respect, purity, and other things, and how it served the society, etc. Why is it that that attitude to keep water pure, clean, and healthy to serve the community is not continuing? Of course, about various water disputes, whether it's relating to interstate one or intrastate one or interdistrict one, we have to adopt an altruistic approach. See, yesterday there was one point made out that if there is an approach of adamancy, ego conflicts, lack of altruism, lack of concern about the demand of others, that a particular section of the society is likely to face a scarcity of water, or say lack of access to drinking water, then the entity which has a certain access to water has the responsibility of responding to the demands of others. If Goa had responded well in advance, say in 1996 or even earlier, positively, the position would have been different. Why was it? Why was there that kind of unnecessary litigation prolonged for say decades, more than 2 decades? See, what was the ultimate outcome? If there was a consensus about diversion of water by Karnataka from Mahadayi to Malaprabha to the extent of 3.54 TMC in 1996, and in 2018 we are getting a wonderful judgment from Mahadayi Tribunal that Karnataka is entitled to 3.9 TMC of water. What is the big achievement? During last 2 decades, Karnataka suffered because of lack of access to Mahadayi water, whether about drinking water, irrigation, or any other thing. We suffered because of such a conflict of egos, political considerations, and so many narrow-minded approaches relating to water. Such a narrow-minded approaches may remain even in the community levels, whether it is inter-tribal relations or say inter-village relations or various other situations, or even relating to access to water, factors of caste, factor of tribe may come in the way. We have, unfortunately, cases like Appabalu Ingle, a case coming from Karnataka. From no other state we have that type of a case where people belonging to scheduled castes or scheduled tribes were deprived of access to right to water.
why is it that this kind of approach prevails in a community which is known for say very good tradition of thoughts about say equal distribution of resources and so many other things. From a 12th century onwards, when we go through the socio-legal values which were emerged, perhaps the ethical principles of those days are not continuing, and there is a need to revive all those values, all those propositions. And with reference to water, unless we determine ourselves, make a commitment to save water, to ensure its security, perhaps we'll be failing in our duty. Karnataka state water policy is in supplement to the national water policy. National water policy has detailed measures, but water is one of the prominent subject in a state list. It's considered that water is a state managed legal subject. That's why the central government's intervention or its negotiating capacity or its capacity to act as an arbitrator or a negotiator, etc., is not a serious matter. It is something to be done from the side of the states. State water policy of 2021 is supplementing the national water policy. It has a very laudable objectives like ensuring water security, ensuring efficiency of urban and rural water supply, enhancing productivity, improving the health of water bodies, moving towards a sustainable groundwater management, improving water governance, managing water resources by adopting integrated approach. Then how to improve the infrastructure of irrigation. About that also, water policy of 2021 has made some elaborate discussion. How irrigation system is to be modernized, then how the infrastructure for irrigation is to be improved, reformed, and how by recycling and various other methods water is to be restored. It was said well by some scholars today, Professor Mr. Mohan Kataki, that water is a natural thing. It is not something that can be created by human being. See, it is a God-given gift, and relating to water, a careless approach may not be appropriate. See, each drop is to be protected. Regarding each and every issue about water use, suppose our engineers or our architects or various other persons contribute in a creative manner, the position would be different. Perhaps in so many hotels or in so many posh houses, we come across an unusual type of thing where, in order to get hot water, one has to waste 1 or 2 buckets of cold water. Suppose that could be saved by some method. That goes a long way in protecting water, because each and every drop of water is so important, and it is to be protected. Relating to protection of water, conservation of water through say
rainwater harvesting, or putting check dams and various other things, or restoring the traditional tanks, or restoring a katta, or various other traditional methods of irrigation. Concerning this, we have to develop that concern, and role of the community becomes quite important. In one district like a Hassan, suppose the creative leadership of a person like a Rupa Hassan could change the whole scenario by organizing a social movement for restoration of water tanks, resulting in say restoration of thousands of kalyanis or pushkarinis or various other water bodies, jalamulas. See, whole society is getting inspiration and getting the benefit of it, and there will be that a dedicated effort even in other spheres of life, because water is the starting point, and other social works will be the areas in which further community work will continue. That's what Professor M.K. Ramesh has said quite elaborately and in a very scholarly manner about the integrated use of water and the responsibility of various participants in the whole process is something quite significant. We in KSLU have tried to make use of resources like the government's permission to establish a water resource center. There is a Center for Research in Water Management and Law, and also Center for Studies in Constitution and Democracy. These are some of the efforts through which we are trying to convert the resources, economic resources, into knowledge resources. And suppose we are able to bring more awareness or more publications or some scholarly understanding of various issues, and provide some solutions or suggest some of the ideas that that could emerge on the basis of discussions and deliberations. We find that the purpose of establishing such research centers will be duly served. During the last 1.5 years, the center could involve in some of the works, and of course, this is one event where the participation of various scholars has something that has supported our efforts. There's the work that we have produced during the last 2 days is something that adds to the knowledge system, and I hope that there could be good publication out of this discussion, because so many scholars have already promised to write papers and contribute, so that we can bring out one edited edition. With this, let me conclude. Let me thank all the persons who are responsible for making this national webinar a success. Thank you very much. It is a great pleasure on my part as a head of the center and also head of the institution to thank all the persons who are responsible for success, making it a successful enterprise. Thank you very much.
Thank you so much, sir. May I now request Dr. Rajendra Kumar Hittangi, Assistant Professor, Karnataka State Law University, to kindly propose the vote of thanks. Please, sir.
Good evening to all. It's a great matter of privilege to propose vote of thanks on this occasion. It is a time to thank all those who have made this national webinar on emerging trends in water resource management and law, with a special reference to Karnataka, a great success. Center for Research in Water Resource Management and Law, KSLU, in collaboration with the Ministry of Minor Irrigation, Government of Karnataka, has organized a national webinar on a meaningful and a very much relevant topic. I, on behalf of university authorities, and the Ministry of Minor Irrigation, Government of Karnataka, express deep sense of gratitude to Professor Dr. M.K. Ramesh, former Professor of Law, National Law School of India, University of Bangalore, for accepting our invitation to deliver the valedictory address and sparing valuable time in delivering thought-provoking valedictory address covering concerns of law relating to water. Thank you very much, sir, for sharing your valuable thoughts with us. Thank you so much, sir. The national webinar of such a kind would not have been possible but for the constant motivation and gratitude and guidance of our beloved Honorable Vice Chancellor, Professor Dr. P. Ishwar Bhatt, who is very much instrumental in arranging this particular webinar and emphasizing on integrated approach to water in his presidential remarks. Thank you very much, sir, for presiding over this particular valedictory function. Our thanks are also due to Sri Mohammad Zubair, N, KAS, Registrar, KSLU Hubli, for supporting us in organizing this particular webinar. I thank Professor Dr. C.S. Patil, Professor of Law, Head, Center for Studies and Research in Democracy and Constitutional Government, for his support in organizing this particular webinar. We are grateful to Professor Dr. Ratna Baramgowda, Dean and Director, KSLU, and Professor Dr. G.B. Patil, Registrar Evaluation, KSLU, Hubli, for guiding us in organizing this webinar. I extend my sincere thanks to all the members of the Syndicate and Academic Council of Karnataka State Law University, Hubli. On behalf of the university and the concerned authorities, I thank all the principals of affiliated law colleges and also resource persons of the plenary sessions and paper presenters. And I will be failing in my duty if I do not mention the contribution made by Dr. Akhila Baslalli, Senior Research Assistant, CRW-RWL, and Ms. Nayasri, Junior Research Assistant, CRW-RWL, in organizing this national webinar. Both of them have taken a lot of keen interest and meticulously planned to make this webinar a great success with the help of committed student volunteers. I thank you, both of them. I also thank all the esteemed colleagues, staff, and students of the Karnataka State Law University for their continuous support. We are also grateful to the members of the press and those who have helped directly and indirectly in making this national webinar a great success. I thank one and all for joining this particular national webinar. Thank you one and all. Namaste.
Thank you so much, sir. We may now adjourn for the day. Thank you, everyone. Have a great day.